Okay, which case is it here on the Commonwealth versus Michael Vibert, 21 CR 00127. Similar to that. See not here. Okay, Mr. Hunley, we call a case of Commonwealth Kentucky versus Michael Vibert. There has been a motion to suppress the warrantless search.
Yes, sir.
Would you like to?
Ready when our officers get here.
Well, I'm ready when your officers get here too. You got one you want to call?
At this moment, we have 3 officers. We have Deputy Parole and Sheriff Scott Daniels, Fairland County, and High Hammer. Mr. Hammer is now downstairs in the presence of the grand jury. And I don't know where Deputy Gerald or Sheriff Scott are.
Okay, well, that's
But
enlightening.
they know to be here. But we did tell them 9:30.
Okay, well, we can go on with the rest of the docket. And I thought you had a witness. I was told that you had a witness that had to be heard at 9. Was that incorrect?
Well, it turns out that it was,
Okay,
because we don't have him here.
okay, okay. Well, let's go ahead with the rest of the docket. Are we going to do in person first? Commonwealth Kentucky versus, you can take this prisoner back and we'll bring you back out when the people come, okay? Commonwealth of Kentucky versus Christy Allman for arraignment.
That's my case. Miss Allman sent me a text a while ago. She has made it long term. She said she'll be here about 9. If the court could just pass that for a minute.
Sure. Wrong turn. That's not an admission. It wasn't an admission, was it? So, okay, Crystal Botts. You gonna file on Crystal Botts? So much. Commonwealth Kentucky versus Crystal Botts. 22 CR 0016 and 21 CR 0086. You are Crystal Botts.
Yes, sir.
Put your mask up over your nose. Okay, thank you. What is your year of birth?
615 Atkinson said
Last 4 digits of your social security number.
6863.
What do you have?
Your Honor, this is on today at the Commonwealth motion to change her supervision over to the Department of Probation and Parole. She does not qualify for the specialty court program due to a lack of transportation.
Where's Jesse?
He switched places with us. I think he's not saying.
What's y'all's position on this?
It was their motion. Please, Your Honor.
Got a feeling that.
Well, you filed a motion, said that she wasn't, your motion says she wasn't going to be able to do the specialty court because she didn't have transportation.
That's part of the reason I approached these.
It's okay. All right.
I believe there's also a corrected plea that needs to be signed.
Great, please.
Was there an order submitted on this? See if there's an order.
I don't ever submit any grants. I don't know. They'll do it.
You're gonna do an order?
We can.
Yeah. Okay. Now, will she need to meet with the probation parole officer?
She will.
Okay. James Carter. Commonwealth versus James Carter. So there's an active warrant out. You know, it.
It's the accident now.
Okay. Seth Collins, sentencing. Commonwealth versus Seth Ari Collins. 20 CR 00080. Are you Seth Collins?
Yes,
Your year of birth?
92.
92. And last four digits, your social security number.
5119.
You're here today for the purpose of sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation parole? Is it correct?
No, Mr. Collins has indicated that his in custody credit on there is incorrect, that he has quite a bit more time in custody on this case. I have directed him to speak with his probation officer about that and go through their process for review.
Okay. Other than that, other than reserving your right to administratively appeal the credit, is there any other thing in there that needs to be corrected? Upon a plea of guilty to possession of a controlled substance first degree, the defendant shall receive a sentence of 3 years, probated for 5 years, supervised. On a plea of guilty to no insurance, he shall pay a $500 fine and cost. He shall enter the Monroe County Specialty Court Program. Shall remain on home incarceration. Is that correct?
Yes.
With work, church, doctors, and court appearances. Commonwealth did agree, however, not to revoke the previous case indictment number 18 CR 00203. Okay, you need to meet with the probation parole officer, Mr. Collins. Had a rather active past.
Mm.
Well,
Yeah.
were you in drug court this morning?
Without your- this one?
Well, I think there's a warrant out for him because he didn't show up this morning, so that makes it taken care of. He was supposed to be in drug court.
What?
Yeah, so you can argue that's straight back.
Judge
I just found
Costello,
out about it while he was doing the sentence.
is Judge Costello still here?
I don't know, there's the ranger down there now, so I'd say the jet drug courts. Mr. Collins can call the problem for you, so yeah, you should have been there this morning.
Send for
Tell me what I've been told.
send for Arlen to come over here. Until then, he's in custody. He's in custody. You need to place him in custody and take him back until we wait, okay? You know, the court cost on that, what was the court cost on that? $220.50. Just give him, he's got $500 too, so let him have $75 a month. Paid in full. Bryson Coulter. Pretty inauspicious way to start out drug court, isn't it? So, how you doing? Commonwealth Kentucky versus Bryson Coulter. Morning, are you Bryson Coulter? born in 70. Last four digits, social security number 5256. Here today for a pretrial conference.
Since we're negotiating this, I'd ask for one more pretrial, but it's all.
I will agree with that.
What is the negotiation day that you have?
May 13th at 9:00.
You want him there on that day,
Yes, sir.
May the 13th for negotiations, and May the 19th is the next rule day. Both of those are conditions of your bond, okay? Robert Cox,
Thank you.
yeah. Robert Cox says active warrant.
Last time I did it, the rest of Tennessee.
Okay. Alan England. Alan England. Commonwealth versus Alan England. 21 CR 00131. We're here today for a pretrial conference. Were you born in 1994?
Yes, sir.
Last four digits, social security number 6877. Okay.
So we have a
Okay, do you have a felony plea or a pretrial diversion?
pretrial numbers.
A motion has been tendered, sir, that says you wish to enter a guilty plea today. Is that correct? Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given?
Yes, sir.
State your full name. Are you the same person named in indictment number 21 CR 00131? Is your judgment impaired today in any way?
No, sir.
Have you discussed these charges with your attorney? Are you satisfied with her advice? Okay. You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept a plea of guilty, I need to know that you fully understand those rights. I'm gonna go down through all of them, then I'll ask you at the end, okay? You have a right not to testify against yourself. No one can make you say anything. Right to speak trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. You're instead of entering a guilty plea, you give up all those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept any recommendation. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea. Have you previously been diverted in the last 5 years?
No,
Do you have any felony convictions in the last 10 years?
No.
Are you currently on probation or? Okay. You understand if you fully complete the diversion program, the charge will be dismissed. If you do not complete it, you will be brought back before the court. Sentencing will be scheduled. Pre-sentence investigation report will be done. You understand? Y'all step to your left. Mr. Stockton, what is the Commonwealth's recommendation?
He started with possession of controlled substance and then get a guilty plea to that, pretrial diversion, 3-year sentence for 5 years supervised. He'll be assessed by the SSC, follow all recommendations, take court cost discretion of the court, maintain or obtain gainful employment, all evidence in this case be destroyed.
Okay, is that what come back over here? Is that what you understand?
yes, sir.
Are you pleading guilty because you committed acts charged in the indictment as amended?
Yes, sir.
You plead guilty of your own free will and for no other reason.
Yes, sir.
Knowing your constitutional rights, as I've explained to you, is to your desire to give up those rights, enter a guilty plea, allow the court to fix your punishment. Is that your signature on the motion and offer?
Yes, sir.
I will accept it. Mr. Bailiff, you hand it up here. Thank you so much. What is the court cost in this case?
$195.
Court cost is $185. You need some time to pay that. Make your first payment 30 days from today, $30. And $30 every month you pay that. Yep. Okay, where'd you go? Noah Freeman. Noah Freeman says active warrant. What's the story on Mr. Noah Freeman? Corey Holland, active warrant. You got that one? Okay. Janesha Howard. Good morning. Commonwealth versus Janesha Howard. 18 CR 00194 and 18 CR 00184. You born in 1989. Last four digits, social security number 8397. Okay. You have a motion.
Mr. Stockton, she was not eligible for drug court. Motion is to return to the 2%.
She was placed in drug court with a revocation. She's not eligible. I'd actually be placed on supervision. I don't mind getting her break this time. I don't have quick treatment.
She have anything going on in Barron?
That's right.
Okay.
I spoke to the probation officer on Monday. She did not know that.
So you're just taking her up to supervised status? Is that what you're doing?
That's all right.
What is she doing as far as talking to any clinicians about any drug problem that she might have?
People refer to life skills. So that's what it's been.
You think they're helping you any at life skills, or are you going regularly, or you think you need to do a rehab somewhere?
I'm working at everything now as well. So
Where are you working at?
jobs in a warehouse, 12 hours a day.
Okay, well, I don't like to send anybody to penitentiary. I like for you to be a productive citizen, enjoy this spring. We're about starting right now, so we'll give you a shot at it, okay?
All right, thank you.
Okay. What about this gentleman that was up here a few minutes ago that was supposed to be in drug court, Mr. Stockton?
Mr. Mink stepped out.
There is no warrant for his arrest, Judge. He was supposed to be at drug court this morning, and Judge was going to issue one and everything else, but since he was up here, whatnot, he's not going to stop him.
Well, he seemed not to know that he was supposed to be there, which I find implausible.
So,
Well, let's bring him back out while you're here. I'm going to talk to him a little bit.
that's fine.
Brian McHugh. You got a holder on him?
We will have.
Okay.
And I can get it back up there. We'll see how that's about that. Negotiate May 9th.
Okay, young man, evidently there is not a warrant out for you here because you were up here. But I am a little unsure of why you didn't know you were supposed to be down there. So you need to check with the officer here and make sure you got the schedule down, because Judge Christie will sign a warrant for you if you don't show up or you violate. And then it'll be up to the decision on whether you get kicked out of drug court. This is not a very great way to start your specialty court career, is missing a day. You know what I mean? So you can talk with Mr. Arlen there. I'll take you out, talk to you a little bit. Okay.
Thank you, Judge.
Yeah. Thank you. Jeffrey Miller. Hello.
Taylor Broderick was defendant.
Cromwell versus Jeffrey Miller, 21 CR 0094. Are you Jeffrey Miller? Mr. Miller, you're born in 1965. Last four digits social security number is 1975, correct?
Yes, sir.
What do we have here today?
My understanding is the defendant's counsel is going to file a motion to spread it here next month. We furnished all of the discovery that we're aware of at this time.
Did you have a warrantless search, did you, or what?
Your Honor, the basis of our suppression motion will begin with the anonymous tip that led to the stop, Your Honor. In addition to that, Your Honor, we received supplemental discovery from the Commonwealth yesterday. It has been sent to my client, but he has not had an opportunity to come in and review it with us.
That's fine, but we get, Ms. Broderick said she filed a motion relatively quickly.
Yes, sir.
We'll be ready.
Okay, well, we'll do, go ahead and brief the topic if you want to, since we're putting it off a month. So you get a brief over on the facts as you allege them to be.
Yes, sir.
You can have 10 days to respond when you get it from her, and you'll schedule your suppression motion on the 13th, and we'll also have a pretrial schedule for that day. They have the suppression order entered, then the Commonwealth can make a decision on how they would proceed if it's suppressed.
Judge, I'm sorry, May 13th.
May the 13th. No, excuse me, May the 19th. May the 13th is a negotiation
Yes,
day.
sir. Okay, I just wanted to make sure. we
Yeah, May the 19th, May the 19th. Okay, Ivan Murphy.
Thank you, Your Honor.
Yeah. Commonwealth versus Ivan Murphy, 18 CR 00168. Mr. Murphy, were you born in 1997?
Yes, sir.
And what are the last four digits of social security number?
1978.
Okay, we're here for pretrial conference.
No, this was a case that was previously in conference out to another DPA office. I was advised by my supervisor last night that the gentleman that was representing Mr. Murphy has left the agency. I've spoken to Mr. Stockton about that. He's agreeable to resetting this for next month to reassign counsel, allow them to speak with Mr. Murphy.
Was it a conflict counsel or what was it?
It was conflict counsel, but was to another DPA office because there were quite a few co-defendants on this case, and so it had to go to another office.
You want him for the 13th?
Yeah, let's try that.
May the 13th for negotiations. May the 19th for your next court appearance. Both of those are conditions of your bond, Mr. Murphy, okay?
Yes, sir.
Daryl Norris has an active warrant issued. Okay. Seems like you're going to have a jail overcrowding in Tennessee here with all. Bobby Pruitt, Bobby Pruitt. Twenty-two CR 00015, Commonwealth Executive versus Bobby Pruitt. Are you Bobby Pruitt?
Yes, sir.
Mr. Pruitt, what year were you born?
1983.
Last four digits of social security number.
3486.
Okay, we're here for a pretrial conference. What do you have? Is a diversion or a guilty plea? Felony plea. A motion has been tendered that says you wish to enter a plea of guilty today. Sir, are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictment number 22 CR 0015?
Yes, sir.
Okay. Is your judgment impaired today in any way?
No, sir.
Have you discussed these charges with your attorney?
Yes, sir.
Are you satisfied with the advice of your attorney?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you?
Yes, sir.
You believe you're fully informed about your case?
Yes, sir.
Okay. You understand that you do not have to enter a guilty plea today.
Yes,
You
sir.
have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you have those rights. I'm going to go over these rights, and to end, I'm going to ask you to acknowledge that you understand them. You have the right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, and have process issued to compel their attendance. You have the right to appeal this matter to a higher court if you lose, the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charges against you. You understand that by entering a guilty plea today, you give up all those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept any recommendation. Prior to accepting any recommendation, I will wait the pre-sentence investigation report from probation and parole. In the event that I do not accept the recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea. If you'll step to your left there, sir, and listen very closely, Mr. Stockton, what do you have?
Your Honor, Mr. Pruitt will plead guilty to burglary to third degree. He'll receive a sentence of 5 years, supervised for 5 years. He'll have no contact with the victim or no real properties. He'll receive credits for time served, pay fine, cause of discretion of court. He will obtain and maintain gainful employment, and and any evidence in this case will be destroyed.
Is that your understanding of the Commonwealth's recommendation, sir?
Yes, sir, Your Honor.
Are you pleading guilty because you did commit the acts as charged? Okay. You're doing this of your own free will?
Yes, sir.
Knowing your constitutional rights, as I explained to him, is still your desire to give up those rights and enter a plea of guilty to the charges and allow the court to fix your punishment within the range permitted by law. You understand that by entering this guilty plea, any future convictions will enhance the range of the penalty. Is that your signature on the motion there?
Yes, sir, Your Honor.
I'll accept the agreement, order pre-sentence investigation report to be done by probation and parole. You're to be back here on May the 19th for your sentencing. You need to talk to probation and parole officer over there. Christina Pruitt. Christina Pruitt. Commonwealth versus Christina Pruitt, 22 CR 00015. Are you, 22 CR 0025. Are you Christina Pruitt?
Yes, sir.
Were you born in 1988?
Yes, sir.
Last four digits, social security number 5658. We're here today for the purpose of arraignment. You have a right to remain silent. Do you have an attorney?
No, sir.
Was it, who represents you in district court? Just go to district court,
It was, I'm not sure.
public advocate's office.
Yes, sir.
I'm gonna continue that appointment. The grand jury of Monroe County has returned in indictment, charged you with complicity to commit burglary in the second degree and complicity to commit theft by unlawful taking under $500. Mr. Bales. Counselor, do you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions? Ma'am, you shall be here on May the 13th for negotiations and May the 19th for your next court appearance, and both of those are conditioned of your bond. Do you understand that?
Yes, sir.
Okay. John Riley, you'll need to meet with the probation and parole officer, I guess, to get the information. Precinct's investigation.
That's a probation. It's on the requirement.
I'm talking about John Riley. Oh, I thought he was here. Was that the reason I thought it was, it had probation revocation out there, so you don't have him yet. Jonathan Scott. Jonathan Scott. Commonwealth versus Jonathan Scott. 22 CR 005 for pretrial, 22 CR 006 pretrial, and 22 CR 0036 for arraignment. Are you Jonathan Scott?
Yes, sir.
What's your year of birth?
1970,
Last four digits of your social security number.
0956.
Okay, you're up here on two charges. You got an arraignment on the other charge, which would be, you have a right to remain silent. You are represented by counsel here. Grand jury of Monroe County has returned an indictment charging you with possession of marijuana, possession of drug paraphernalia, and possession of controlled substance in the first degree. Counselor, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, sir.
Okay, Mr. Stockton, where are we on this thing here with?
22 CR 36.
Yeah, I just did that.
Okay, negotiation date on the 13th.
Okay, negotiation date on the 13th. Your next court date is on the 19th. Both of those are conditions of your bond. You understand? Okay. German Serrano. I'm entering a new reciprocal discovery order on that last case. Is he riding with Christy Allman?
So he did report us to associated to Mr. Collins yesterday. We're not sure he needs to be here. This is the case that is in a conflict phase. And so I didn't have contact information for him until he was today, that Mr. Collins is looking at work. So I asked him to reschedule it for next month.
I'm not kept following what you're saying here.
Mr. Serrano is at work. We're not sure he needs to be here.
He's at work.
Yes, sir, but we're not sure he needs to be here for that.
Where is he at work at?
Stevens drug.
Are you pretty confident that he wasn't informed to be here?
I think maybe he was supposed to report. I have to go back and look at my notes. But I didn't inform him to be here.
And this is a case that he's in conflict counsel, and our contact information for him is.
Who was the conflict counsel?
Mr. Brown, but we take it over when it's the revocation, but his contact information that we had was no longer up to date. So we were not able to notify him of that.
He's on probation. He got convicted of a DUI suspended license, not DUI, but a suspended license. That's the basis for the revocation. I just want to bring it before the court. I do know I've dealt with him for years. He works. He doesn't work. I don't think any doubt about that. He's not going anywhere. He couldn't run him off in Monroe County.
Well, I'll schedule him for the 19th, but Mr. Stockton, let's try this with him. Let's have him to come in on the 13th to negotiate, and if it's to your satisfaction, we won't put him on the docket, but and if you want him on the docket, the date will be the 19th.
Thank you, Your Honor.
have so few people who work, we're bound to be some kind of reward. Alicia Wallace, active warrant. You know the story on Alicia Wallace?
I did it one time, but I didn't write it down. Secretary got that file yesterday. I think she's been arrested in somewhere in the place and still trying to figure out some way to make the
Okay, we'll schedule it. I guess we can't schedule it for anything because it's an arraignment. We got to do, we don't have her in front of us yet, so. Tommy Webb. This is active warrant.
He got a new felony arrest for manufacturing length, so.
That's novel these days. You don't see very much of that. Got somebody to swear?
No, they're done.
I don't think she's got it. I don't think she's got the paperwork.
Okay, they're just sitting. The district court is needed.
Well, we've got this other courtroom, family courtroom. Just take them in the family courtroom.
It's just, yeah, right out there.
Doyle, will you help us here and help Lanny take the grand jury to the family courtroom? Kelton Withrow.
I think we have a written on this case, we're just waiting for the plea paperwork.
Justin Wood. Justin Wood. Commonwealth versus Justin Wood, 22 CR 0029. Are you Justin Wood? You're here for a pretrial conference. Y'all have anything worked out on this case?
Yes, we have a motion to enter a plea to diversion, Your Honor.
Okay. Mr. Wood, were you born in 1986? Last four digits of social security number are what? The motion has been tendered that says you wish to enter a plea of guilty today. Is that correct? Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given? Are you the same person named in indictment number 22 CR 0029? Is your judgment impaired in any way today? Have you discussed this charge with your attorney? Are you satisfied with his advice? Have you reviewed all evidence the Commonwealth has against you? Do you believe you're fully informed about your case? You understand that you do not have to plead guilty today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea from you, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. Right to speed trial by jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses, and have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose. You have the right to require the Commonwealth to prove beyond a reasonable doubt you're guilty of charges. You understand that by entering a guilty plea today, you will give up those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept it. In the event that I don't accept the recommendation, and decide to impose a harsher sentence, I will allow you to withdraw your plea. Have you been previously diverted in the last 5 years? Do you have any felony convictions in the last 10 years? Are you currently on probation or pretrial release? Well, I mean, are you hesitant about that? Are you on?
I think he just didn't understand the entirety.
Okay. You understand if you complete the diversion program, the cases will be dismissed and you can have your record expunged. You understand that? You know that if you do not complete the diversion program, you will be brought back before the court, and the court will schedule a sentencing hearing. And at that time, you would be a convicted felon. And your sentences could be enhanced. You understand that? If you move to your left there, sir, Mr. Stockton will come around. Listen very carefully, sir, and see if this is what you agree to, Mr. Stockton.
Your Honor, Mr. Wood will plead guilty to burglary, third, 4 counts, and 1 count of theft and unlawful taking over $1,000. He'll receive a sentence of 3 years on each of those charges. He'll have those will run concurrently for a total of 3 years. Pretrial verdict for 5, supervised. He will pay $1,040 plus the first fee restitution today for the victims in the case. He'll follow all recommendations of the SSC. He'll have no contact with any victims and should not be on the premises of Hidden Hills Country Club during the penance of conversion. He'll pay court costs of discretion of court.
Okay, is that what you agreed to? Come back over here. Is that what you agreed to? Are you pleading guilty because you did commit the acts that you've pled to?
Yes, sir.
Okay. Knowing your constitutional rights, what I explained to them, it's still your desire to go ahead and enter this plea of guilty and allow the court to fix your punishment. Okay. So what we're going to do here is I'm going to agree to the pretrial diversion. I'll accept the agreement. Could you retrieve it? Is that your signature on there, sir? Okay. What are the court costs in this? $215 court costs. You need some time to pay that? Okay. You need to go over and meet with a probation parole officer so we can get some information about you, okay? Okay, I guess we had Christy Allman. You have the paperwork done on Kelton Withrow yet?
They're ready for the suppression.
Okay. Commonwealth versus Christy Allman. Are you Christy Allman?
Yeah.
Oh, yes.
Okay. Were you born in 1982? Last 4 digits of your, pull that up over your nose. You'll have to just pull it way on up there. Okay. Last 4 digits, your social security number 2744. You're here today for purpose of arraignment. You're represented by counsel. You have the right to remain silent. I suggest if you anything said that you don't understand, step away from the podium and talk to your lawyer. The grand jury of Monroe County has indicted you on operating a vehicle with alcohol concentration above 8 or while under the influence, possession of controlled substance in the 1st degree, possession of controlled substance not in the original container, failure to maintain insurance on a motor vehicle as required by 304 KRS chapter 304, and possession of drug paraphernalia. Mr. Bailiff, and that you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty. Thank you. Enter plea. Sign a reciprocal discovery order. The bailiff has handed your attorney some information to help prepare for your defense. You need to be back here on May the 13th for negotiations and May the 19th for your next court appearance. Both of those are condition of your bond, okay?
Thank you.
Okay. Okay, now we've got one person and then you got the suppression motion that you're ready for.
Commissioner Whitlow, I think they need time to go.
Okay,
They said this hearing is probably gonna take about an hour. I don't know if you want me to check and see if they got the paperwork down. Before you start the-
yeah, it ain't gonna take no hour, but it'd be good to check on it. Mr. Huntley can try a case in an hour, you know he doesn't.
Takes me to a break.
Y'all ready on Michael Vibert?
You are ready, Your Honor, but I would suggest that it's not appropriate for the grand jury to sit down there because they are through.
Well, I'm waiting for the paperwork to be finished. I've already told them as soon as I get the paperwork finished, I'll come down there.
They're done and they moved them back here, so we'll have to bring it out in the courtroom.
I can go back in there.
You can't record it.
Oh, they can't report. Okay.
It was strange morning. I'm about 15 minutes behind.
It's a wonderful day in the neighborhood. Are they you got the paperwork done on the grand jury?
The one person that's the paperwork. I'll get it.
Well, they need to keep it. We need to bring them out here and let them report, okay? Yeah, go, Mr. Bailiff. The jailer can go. Why don't you go? We all clear the area here, you attorneys, just go back over on the front row, back in the. Thank you. All rise to the grand jury, please. Mr. Foreman, have y'all completed your work back there? If 9 or more of you agreed on the document that you have there, Mr. Bailiff, you recover that, hand it to me. Y'all can be seated. Okay, the papers appear to be in order. I'll even have, if the individuals are in custody, I'll probably have a summons issued for them. If they're not, we'll have a warrant issued for them and we'll put a bond on it sufficient to secure their attendance here, or if they appear to be a danger to protect the public as far as recidivism is involved. And then they'll be picked up and they'll call me on my cell phone and we'll make sure that everything's copacetic, and then we'll get a bond and have them back up here. It's a shorter day than usual here. So your next day, I guess, is the 19th. Is that correct? May the 19th, and let's call back in special session. So you are excused and have a wonderful day. All rise to the grand jury, please. Mr. Bailiff, will you lead them out this way? Thank you very much. Everybody can be seated. Now, you want to get the Kelton Withrow thing out of the way before the suppression hearing, or
Whatever the pleasure.
y'all had enough time to look at that? Who's doing that? Okay, well, let's go ahead and do Michael Vibert then. Commonwealth versus Michael Vibert.
No, I'd like to be heard. Briefly, initially, explain or to just put some background on what we're reading today. and what-
Yeah, it'd save a lot of time if we don't have to have witnesses at these things.
Good. That's what I'm trying to-
Okay. Go ahead.
Thank you, Judge. Judge, this is, as you know, is a motion to suppress.
Yes.
The evidence in this case is going, now the motion was of the defendants was framed as if this is a traffic stop and a dog sniffing case. Commonwealth proof is going to show that that's not accurate. There was an automobile involved.
Well, I understand there was a search warrant. They went to a location. There was an automobile outside. They stopped the person because the search warrant allowed them to search anybody on the premises. Is that right? Or what was it?
No, not exactly.
Well, tell me then.
The case was initiated by Officer Cumberland County, Sheriff's Office over there, Second State Police Brown from over there, in cooperation with the Sheriff's Office here and the City Police here, to execute a arrest warrant on a young lady by the name of Savannah Branham.
Okay.
Ms. Branham has quite a history of flight and evasion. In fact, I believe the last time that they had her cornered before this, she dove out of the window and escaped. So that explains the number of officers that were involved. The proof is going to be that they arrived at the house of Mr. Copus, and when they arrived there, Mr. Vibert was sitting in a car that was parked in the driveway. Officer Deputy Gerald will testify that the first thing he saw Mr. Vibert do was to make a fugitive type move toward the back of the car as if he were concealing something. Officer Gerald knows Mr. Vibert, knows him well. He has a long history of working with Mr. Vibert, who has a long history of drug involvement and other matters that quickly called the officer's attention to the move that he made. Now, of course, the officer's main attention when they first got there was on getting Miss Branham. Some of the officers went back, some of them went to the door, and they got her for that incident. They then turned their attention to Mr. Vibert. Officer Gerald, who faced him initially, asked him, "What are you doing here?" And he told Officer Gerald that he was there to fix and work on a car. Now, this was at 10:30 at night. And then the officer will tell you, and this will be confirmed by Sheriff Scott Daniel from Cumberland County, that in their opinion, Mr. Vibert was extremely nervous, and their opinion was likely high on something. The officers called in he told them that he was there to work on a car, and then he denied owning the car because he was sick. He didn't, not only denied it, he said, "I don't know whose it is." So he lied twice to the officer. Then Then I think the officer ran the vitals on the car and found out that Mr. Vibert, if he was driving on DUI suspended license, that the automobile there that they eventually searched had erroneous license plates on it, and that they had no insurance on the vehicle. Further, that the person showed that he was on probation at the time this occurred for drug-related activities. And that he had at one time waived his Fourth Amendment rights, although the wording was couched in terms of his quote officer, which I took it to mean probation officer. But at any rate, at that point, the officers had 2 drug dogs that they had brought in to check the house of Savannah Brandon. One of the dogs was used to go around Mr. Vibert's car, and it hit on something. Then they actually searched the car. We have a video that primarily, if from a body cam, which primarily covers the actual search of the car, not all of the events that led up to the probable cause to search the car. So, and they found there 16 grams of meth, bombs, digital scales, $600 and something in cash, and bags
In the car?
in the car. That's going to be the first comment.
You can put that mask back up on there if you want to. You need another one that hit the floor there.
Yeah.
Is that one all right?
I don't think either would do any good.
You ought to invest in some money and get you one like your co-counsel does.
Well, I know.
Okay, well, you want to make a statement? Now, your argument, your argument will be that they didn't have any right to hold him, and if they did have any right to hold him, they held him too long, and then the dog got there and found all this contraband. Is that what your argument is?
Correct, Your Honor. My argument is essentially that they came to this house with the intention of serving a arrest warrant on an individual who was there in the house that was not Mr. Vibert. They did find Mr. Vibert in a vehicle outside of the house. Like I said, he was not named on the warrant.
Well, it was an arrest warrant.
Yes, Your Honor.
See, when I browsed through it, I thought it was a search warrant initially when I reviewed it last night. Well, do you think they don't have a right to identify this individual when he's there located where they're going to arrest somebody? They asked him for identity if it was his car. He said it wasn't his car. So he's sitting outside a place where a fugitive is in a car that's not his. Now, what level of inquiry can they make?
Your Honor, I do believe that they have the right to require as to his identity, but after his identity had been verified as well as the reason for him being there, I believe that he should have been released and that.
Well, so they asked the identity while he's there. He says he's there to work on a car, but he says that the car he's in is not his and he doesn't know whose it is, right?
Correct, Your Honor.
Well, then what are they supposed to do? He can't leave in a car that's not his. So by this time, they're all inside doing that and the drug dogs get there. So, I mean, how did they hold him beyond a period that they were allowed to as they investigate the scene?
Your Honor, as the police report reads, they, after they removed him from the vehicle, they had him moved up towards the house where he was kept there until the arrest warrant had been executed. It is my argument that because his identity had been verified and his reason for being in the house had been verified, that he should have been allowed to leave, even if not in the vehicle, he should have been allowed to leave.
So you don't challenge the facts, you just say the facts don't uphold the search.
Yes, Your Honor. The facts are
Okay,
not-
so there won't be any reason to take any testimony. What would you say in response to that, Mr. Hunley? You finished? You got something else? I don't want to rush you.
Your Honor, the only thing that I have is that if we are not going to be introducing witnesses today, I would like to request an evidentiary hearing on this case.
What kind of evidence are you hearing on this motion?
Your Honor, on the case itself, I would like testimony to be presented that supports the things that have been stated here today.
Well, we'll have a hearing then. I thought I was going to ask you if you wanted to stipulate to these facts, if you had any facts that you take issue. If you don't take issue to any of these facts, why do you want a hearing?
Your Honor, I would like to hear the testimony from the officers themselves. Some of this information is not included in the discovery that has been provided.
Okay, we'll have one then. Okay. Call your first witness.
Lucas Girl.
Officer Gerald, you raise your right hand. You swear the testimony you're about to give us the truth, the whole truth, nothing but the truth.
Yes, sir.
Have a seat. State your name, with whom you're employed, in what capacity.
Lucas Girls, Monroe County Sheriff's Department.
Deputy Journals, were you employed with the Monroe County Sheriff's Office on October the 11th, 2021?
Yes, I was.
And are you familiar with Michael Shane Vibert?
Yes, I
Is
am.
that Mr. Vibert's lead activity was taken?
Yes, it is.
And are you familiar with the events that occurred on October the 11th, of 2021 that involved Mr. Shane? Please tell the court how you been in contact with you.
So, as Mr. Hunley said, I had received a call from Sheriff Scott Daniels from Cumberland County Sheriff's Department, and he advised that they had an active arrest warrant on Savannah Brown, and that they had information that she was at Joe Copus, goes by PJ Copus, that he was at 886 Bill Ferguson Road is where she was supposed to be hiding out.
Is that in Monroe County?
It is. So, Monroe County Sheriff's Department, Hawkinsville Police Department, Kentucky State Police, and the Cumberland County Sheriff's Department, we all met at a location and then went to this resident at 886 Bill Ferguson Road.
And why so many officers, why were there so many officers responding to this?
Because this lady was a major flight risk. She had already escaped once from custody. So that's why we took her there where we could search the house and cover every corner. Also, on this particular residence, we've been getting several complaints and traffic coming in and out of this residence. So it made sense after we found out that she was supposed to be here based on a lot of the calls and complaints that we've got from this actual residence anyway.
Were any dogs, did they accompany you on this? Did the
Canine.
officer bring a canine?
Yes, yeah, they was all present from the time that we all pulled in at the same time.
Once you arrived, what happened then?
So I was the lead vehicle. As I come up to the top of the driveway, I kind of pulled in behind where Mr. Vibert was sitting. He would have been to my right. As I pulled in, I seen a male subject sitting in a vehicle in the dark outside the residence. As I got out to walk towards him, I did notice movement, very nervous acts. I know Mr. Vibert very well. We go back to when we was teenagers. I walked over to his vehicle. Some of the other officers kind of fanned out around the house to make contact with him because that turned into a different issue for us with what he's doing and then what we've got going on inside the house. So at that time, I asked Mr. Vibert what he was doing there. Like I said, he was very nervous. He got out of the vehicle. He was detained just for the time being. It was a very short. We walked to the door. The owner of the house come out. He advised that Miss Brown was upstairs. Probably didn't take three to 5 minutes for us to go upstairs, make an arrest on her, bring her back down. Focus went right back to Mr. Vibert.
So where was Mr. Vibert standing after you came outside the house?
He was out sitting outside with one of the deputies from Cumberland County, and I think Officer Cody Ford and Officer Ty Hammer was standing outside with him. The best of my knowledge that I remember.
From where the car was parked to the house, how many feet was between that?
I would say 40 to 50 feet from the house.
And Mr. Vibert was standing next to the home?
Yeah, he was actually standing after I asked him to get out of the vehicle, he actually stood there by some kind of little ramp porch area that goes up to the house. He kind of had a seat right there.
Like you come out of the house with his friend, what happened next?
So, we then spoke to the owner of the house, Mr. Copus, PJ Copus, and he advised us that he had no clue that Mr. Vibert was outside, no knowledge whatsoever. And also, Mr. Vibert told me the same thing. He said, well, they probably don't know that I'm even out there.
When did he make that statement to you?
While I was there talking to him.
Like whenever you first approached him?
Yeah, well, after she was arrested, like I said, it was just a very few minutes. That's when we took our attention back to Mr. Vibert, to try to figure out what he was doing while he was there. And that's basically what he told me. I remember telling him, I said, well, the owner doesn't know you're even here, and he said, well, he probably don't.
Is Mr. Vibert the one that told you that he was there to work on the vehicle?
He is, yes.
When your attention turned back to him, what happened?
Well, after that, I talked to Canine Officer Ty Hammer about doing a sniff around the vehicle. Of course, I won't testify to that part because it's not my expertise, but he did do that, and there was a scent gathered from the canine. And at that time, that's when Officer Hammer, the best of my knowledge, spoke to Mr. Vibert about what his dog doing, what the next step was.
From the time that you asked Mr. Vibert to exit his vehicle, how much time passed from that moment to the time that the canine did sit?
I'm gonna say less than 20 minutes. Probably closer to 15, because it went really fast from the time we went in the house, arrested her, brought her right back downstairs and outside.
Prior to October 11th of 2021, what knowledge did you have of Mr. Vibert?
Well, knowledge-wise, Mr. Vibert's always been good as far as, he's not a dangerous character, nothing like that. He's had a long history of drug use, drug trafficking, pursuits, driving on suspended a lot, just things of that nature.
To your knowledge, did you know that night that he had a license?
I knew he did not have a license. That was knowledge by any officer knew that he was suspended.
As far as the search of the vehicle, what was your role in that?
I participated in the search with Officer Hammer, and I can't recall the deputy's name that was actually there helping us too with the actual search of the vehicle after the fact that the canine done his work.
What was found in the vehicle?
So in the vehicle, it was roughly behind the driver's seat. There was a white cell phone box, it had some writing on it, I've got it printed on the citation. Inside that box, there was let me tell you this so I'll get it right here. Several baggies that contained a white crystal substance. They did field test positive for methamphetamine. Also inside this little box is individual baggies of a scale, meth pipe, meth bomb found inside the vehicle along with cash. And then, of course, the meth weighed out at 16 grams.
Did anybody check the vehicle for insurance or registration?
Yes. While we were standing outside the vehicle trying to figure out exactly who the vehicle belonged to, and it was my knowledge that the vehicle did belong to Mr. Vibert. But when we ran the vehicle, it come back to a totally different vehicle. So at that time, we had to run the VIN number. And Sheriff Scott Daniels done that part. He contacted his dispatch and he done that part as far as getting the information.
Did Mr. Vibert make any statements pertaining to the ownership of that vehicle?
The best I remember, he did tell me it was his vehicle.
I have no other questions, Ms. West.
Would you like to inquire?
Also told us that he just opens his door up for people that need a place to sleep or whatever.
And Mr. Vibert, he was outside of the home when officers arrived.
Yes,
And there was no indication that he had been inside the residence that day.
I have no idea on that.
It says in the Kaiser report, and you testified today, that Mr. Vibert appeared nervous whenever you approached.
Absolutely.
Can you explain what you mean by he appeared nervous?
Yeah, just, fidgety, sweaty, some of the movement that I seen as I was pulling up the driveway, and that's basically the, the signs that I look for. We're trained, experienced, doing this as long as I have, that you notice those things, those are signs that you watch for, just different body languages and stuff.
So he appeared nervous, but not threatening in any way?
Right, yeah.
So at that point, that's when you had him step out of the vehicle
Yes,
and you patted him down?
yes,
You didn't discover anything during the pat down?
no,
So you asked him to step near the side of the house?
yes.
During your encounter with him in the vehicle and during the pat down, did you have a clear view into the vehicle?
It wasn't a clear view, because obviously it's, it's dark out, and so as I walked towards his vehicle and approached him, I asked him to get out of the vehicle, because, at the time, we don't know what we're dealing with, we don't know what's going on.
But as far as what you could see, you didn't see anything?
Well, at that particular moment, I didn't worry about actually looking in the vehicle. I just wanted to make sure that we had him detained where nothing was gonna happen. And that way we could do the task that we was there to start with.
I have no further questions. Thank you.
Redirect.
Two more questions, John. Did Mr. Vibert at all ever deny that it was his vehicle?
I can't remember, but I do remember when we got there, he advised he was gonna work on the vehicle. And it seemed like,
Is he referring to the vehicle that he was in?
yes,
You said he was making some movements that alarmed you. What kind of movements?
well, as we pulled up and I was getting out, I just noticed like some quick movements around, which of course it's dark. So I could definitely see some movements, like some body movements turning. And then as I approached him, I remember saying, "What are you doing, Shane?" And he was really nervous, sweaty, and that's when we got him out of the vehicle.
Anything else? Mop up.
So we keep going back to the movements that Mr. Vibert was making. When you approached the vehicle and you could see Mr. Vibert in the car, was he doing anything specific at that time?
Well, it all happened so quick. As I pulled in, I seen him. As I was walking up to the vehicle, I seen the movements. I knew immediately it was Mr. Vibert. Like I said, I've known him for years. And as I'm walking to the vehicle, I seen the movement. And I'm asking him at the same time, "Shane, what are you doing?" And that was basically the end of that, other than us getting him out of the vehicle, placing him outside the vehicle by the house until we got the lady arrested and back down.
So when you asked him what he was doing when you first approached, did he verbally respond to that?
So he was there to work on the vehicle.
Okay. And just one follow-up question. We know that as far as people on the property at the time, it was Mr. Vibert, Ms. Branham, and Mr. Copus. Was there anyone?
Yes,
else
there was
present?
another male there, but I don't have his name in front of me.
And did anyone arrive during the time that this search was taking place?
Yes, I think his daughters, but they never come up to the residence. They stayed at the very bottom of the road because the driveway is kind of long uphill. That time an officer went down and spoke to them. And then other than that, it was just the roadback driver.
Okay, that's good. Thank you. You want to make your argument?
Well, we have Sheriff.
I don't see what else they would add if you've seen anything in particular that they add.
Oh, Sheriff Daniels.
Nobody doubts that they had a warrant, that they went to serve the warrant, that the warrant came from Cumberland County, and they went there and arrested the woman on the warrant. They had a history of fleeing, so they took extra officers with them. It's dark.
Sheriff Daniels used to say, Mr. Bibert's condition as being.
Okay, okay.
Nervous and so forth.
Thank you, officer.
Yes.
You raise your right hand. You swear the testimony you're about to give is the truth, whole truth, nothing but the truth.
I do.
Take a stand, state your name, what your position is.
Scott Daniels, Sheriff, Cumberland County.
How long have you been sheriff and in law enforcement?
Sheriff for right now 8 years, and I was in law enforcement for about 6.5 before that.
You know Mr. Vibert?
Yeah, I had a pursuit with him just a few years ago.
Did you know in person?
I do.
And you've heard the testimony here today thus far, is that correct?
That's correct.
Where were you and let's go back. What was the reason for all the officers gathering up on this case to get this one young lady?
Miss Brandon, we had a pursuit with her in Cumberland County where she was running from us and wrecked her vehicle. A few days later, we went to a residence that she jumped out the end window on us and went running, and we never located her. So then we made sure we took enough people with us because we definitely wanted to try to get at this stuff.
All right. And where were you in the line of traffic as they pulled up to the Cope's house?
I was either third in line or fourth in line, I'm not sure.
And then at what point did you see Mr. Vibert at that?
When I started to pull up, I hit my front lights on my truck. It's a big flood that floods out everything. Just, you can see a lot of stuff out there. I just noticed somebody to my left when I pulled up in a vehicle. At that time, I didn't know it was Mr. Vibert. I didn't know who. We was kind of concentrating on getting around the house where she bailed out again. We make sure we get her.
Did you send the officer to the rear of the house?
Yeah, we surrounded the house.
And did you make entry?
Me and Detective Brown or Sergeant Brown now, we talked to the owner of the resident there to beat on the door.
At what point did you talk to and see Mr. Vibert to know that it was Mr. Vibert?
Only guy when Detective Gerald got him out of the vehicle, I knew at that point it was Mr. Vibert.
All right. Did you hear any of the conversation that took place between him and?
I actually went over and talked to Mr. Vibert after we was concentrating on getting her, and he got in the tank for a minute. We didn't know who else was gonna be in that vehicle. Obviously, we didn't know she would be, and she was supposed to be in a white vehicle too, which there was a white truck there in his vehicle. After we talked to the owner there, he'd give us consent to search anywhere we wanted to look for anything, because he said he didn't have nothing to hide. At that time, we found Tyler Wright, Savannah Branham upstairs, Mr. Copus was downstairs. At that point, we come back out. We set Tyler and Savannah down on the steps just over from where Mr. Vibert was. Mr. Vibert, pretty cool. Mr. Vibert was sweating like crazy. I thought we should have been sweating more than he was with us working, but he was sweating like crazy. It was just jittery, just
I would have thought he'd been intoxicated on methamphetamine, to be honest.
Was that your observation?
It was.
At what point did you personally learn from the work of the other officers that he had a DUI suspended license, that false plates on the car, no insurance on the automobile?
Well, I knew he didn't have a license myself.
How did you know that?
Well, I just had that pursuit with him. I knew he pled guilty, I want to say 8 to 10 years, and he'd been put on probation for 5.
So you
spent
had
a couple of years.
You had close familiarity too, Mr. Booth.
Yeah, I run him my way to the city limits of Vibert, Hartsville, when he come out of the house he was supposed to be in.
Based upon your experience as a law enforcement officer, once the drugs were found in his car, would it have been prudent to allow Mr. Vibert to get in the car and leave?
He don't have a license, and the car plates didn't come back to him on our own.
Do you believe that his ability to operate a motor vehicle would have been impaired from what you observed?
I would never let him live like that.
So,
Meanwhile,
Sheriff Daniels, did you speak to Mr. Vibert before or after the canine search?
I'm not 100% sure if I spoke to him, if it was right before, or I'm not 100% sure. I know I talked to him 2 or 3 times, but I mean.
You said that during this, he was sweating and nervous,
Yes, ma'am, I'm sorry.
and your determination that he was intoxicated at the time was based on that.
Well, it's just jittery. I mean, when people can't sit still, and, I mean, if I'm sitting in cuffs, I'm probably gonna be as good as I can be. Honestly.
Sheriff Daniels, how many officers were on the scene that night to your memory?
Well, it would have been me, Deputy Watson, Deputy Gerald, Officer Hammond. I don't remember the other officers' name from T-Bill, to be honest with you, and Sergeant Kenny Brown from State Police.
And the canines were on the scene the entire time that you were there as well?
We all rolled in at one time.
Okay.
To be honest with you, both of them were my dogs, and she put everybody's life in danger for the last 2 times. I wanted to get it, to be honest with you.
Do you remember Mr. Vibert's daughters pulling up at the residence?
I do, I talked to her.
Can you tell us what they told you?
Yeah, I can tell you exactly what they told me. They said they thought it was pretty dead sorry that he would even be up there where he was at while they was flying her mother out because she had COVID and was dying.
Did they tell you why they came out to the residence that day?
Because they couldn't get a hold of him.
I have no further questions. Thank you.
make your argument, Attorney.
I have one, we need to recall Officer Gerald, Your Honor, for one question.
Okay. May the Sheriff Daniels be excused? Sheriff, you may be excused.
Was the vehicle seized that night?
Yes, it was.
And are you the one that called the tow truck?
I did.
And you will still have that vehicle?
It was towed to Brian Frozen's at his welding shop.
Why was it seized that night?
Because, well, drugs were involved. There was no insurance on it. There was tags come back from that absolutely totally different vehicle. So with all those.
Okay, that's all the questions I have now.
Okay, you have any other witnesses?
No other witnesses.
Would you like to be heard?
Yes. Your Honor, as I stated in my brief opening, it's Commonwealth belief that this is not a traffic case, not a traffic stop. This is not a case of the dog sniff. That's not the issue here. This is just an old time issue of did the officer have probable cause to search that vehicle? And I submit to you that they had more than enough probable cause and that there's nothing. I think this is a perfectly good search in all aspects. One, I don't think it's in question that both officers thought that Mr. Vibert was impaired and it would have been imprudent for them to have allowed him to leave in that vehicle because he had no license. He was DUI suspended. The car had switched plates on it. It had no insurance. How could you put a vehicle like that on the road? And they properly towed the car in, which means that if they hadn't found anything on it, or if they hadn't made a search even, they still would have been allowed to make an inventory search of that car, which would have been part of the process, part of their procedure. And that the inventory search would have inevitably found what they found.
Well, how about the dogs?
Well, I think the dog is not an issue here.
Well, if it was an issue, they didn't call the dogs to search his car.
No,
The dogs were already
for a
there.
Totally different reason.
Okay. You have anything else?
And as far as the detention period, as I believe that Mrs. Anderson had showed that it was very.
What did they
reasonable.
charge him with it?
Well, they didn't charge him with anything except the drug-related cases, but they could have. I think they just didn't want to pile on.
No. Okay.
I still argue that there was no probable cause or reasonable suspicion for the search of the vehicle, the detention of Mr. Vibert for the length of time that it took for this to take place. The officers have testified, of course, that they were not there that night for an arrest of Mr. Vibert. They were there for an arrest of an entirely different person who was inside of the residence while Mr. Vibert was outside of the residence. After Mr. Vibert had been identified, I believe that he should have been released at that time.
What if they thought he was under the influence? He was in a vehicle. They knew his driver's license was suspended. It had a false plate on it. And he was outside. It was dark. They were trying to apprehend somebody. They didn't know whether he was there involved in her escaping, didn't know whether he had a weapon on him. What about all those things? The dogs are already there. They didn't call the dogs.
Your Honor, regarding Mr. Vibert's nervousness at that time, they did testify that there were 3 different law enforcement agencies that pulled up to this residence at one time, multiple different officers, 2 canine dogs. I would say that just about anyone would be nervous in those circumstances.
I don't think I would be nervous. Would you be nervous?
Your Honor, I believe
I
that.
guess you would be nervous if you had a lot of meth and some needles and some things in there. You might be nervous, but I'm sure you don't have those. Okay, well, thank you for your argument very much. I don't even think this is close. Mr. Vibert was out there operating a vehicle, control of a vehicle. He doesn't have a license. They know he doesn't have a license. He got a bad plate on it. He just happened to be at the wrong place at the wrong time. I don't know whether he was involved with anything going on. He said that they didn't know on the inside he was there. The person there said they didn't know he was there, but he was there and they pulled up. I think it would have been gross incompetence for these officers to pull up there and not secure that vehicle to see if there was anybody involved. Had anybody had a weapon they're going on? It was involved where the woman was in the car. It's not even close. So I'll draw up some written findings in the thing and we can proceed. But thank you for your good job. Both of you did on it. Okay. Let's go back to the docket. Which one of these, do you think we ought to do Pike County first? I'm going to go to Pike County since you're in the Eastern time zone. Are you on there, Pike County? Okay. Commonwealth versus Brittany Carnes, 21 CR 0085. Are you Brittany Carnes?
Yes, sir.
Okay, we're here today on a pretrial conference. Would you see who? Mr. Bailiff? Mr. Bailiff? Would you see where DPA is?
Your Honor, I'm present.
Put up there, okay. Okay, this is Miss Brittany Carnes, 21 CR 0085. We're here today for a pretrial conference. What do you have?
Your Honor, I contacted Mr. Stockton last week regarding Ms. Carnes. I have been having quite a bit of difficulty getting in touch with the Pike County Jail. And I have sent him an agreed order to have her transported to the Barron County Jail while this case is pending so that we can get it resolved. If we could just get her down here prior to the next pretrial conference.
What's she being held in Pike County for? I don't know whether I have the authority to direct where the Department of Corrections keeps someone confined. I can have her transported down here for a hearing. But Ms. Carnes, what are you doing in Pike County?
State time.
Oh, you're a state prisoner up there.
Yeah.
Okay, well, I cannot enter an order directing the state to replace her. They've made a placement there in Pike County. So if you want her brought down for a hearing, maybe we can do it the night before where you could stop and see her or something like that. What do you have to say about that, Mr. Stockton?
I wonder if it'd be possible to bring her down for the negotiation day and leave her until in Barron County until after court and then transport her back to Pike County. That'd be about 6 days. I'm just thinking out loud. I wonder if that's possible.
Well, I can always issue an order to do that and we'll see.
Yeah, that way the jailer wouldn't be so, busy on that court day. Just he could do it before and afterwards.
Think of it. Is the jailer going to transport them? The sheriff transport them? Their state
Sheriff, I mean, yeah. If we had a definite time limit on it, it might work. I don't know. Because she's entitled to be here in court, I know.
Well, I'm going to issue an order from the transporter and just go ahead and draft it and say if it's all possible, the court would request that she stay here until the rule day.
Yeah, Miss Hill can do an order. I'll sign it.
Okay. Was that be a job for the sheriff or the jailer?
He's having some fun now.
Okay. Okay, thank you. Thank you, Pike County, for your cooperation. Let's go to Rotor Complex. And then we're going to the Warren County Jail after that. Rotor, we have Jared Lawson, please.
Yes, sir.
Okay, Commonwealth versus Jared Lawson, 21 CR 00011. Motion for forfeiture. Is there any objection to this?
Judge, my only concern is that if Mr. Lawson chooses to proceed with any post-convictions actions in the future, I don't know if they are going to want that available if they need to look at anything.
It's the evidence. I tell you what, I'll withdraw my motion to destroy the evidence and just forfeit the $105. I don't know if that would be any problem or not. And if that's a problem, we'll just hold it.
I think if there's pictures of that, or I think that's fine. Since
No, I'm talking about just the money. Yeah.
Mr. Lawson, do you have any objection to that?
For what now? Excuse me.
Mr. Stockton is asking to forfeit the money, the $105.
I don't have no objection to it now.
Okay.
No, we have no objection to
We'll
that.
do an order. Thank you very much, sir, for Rotor. Thank you all for cooperating. We'll enter an order. Okay. Thank you very much. Let's go to Warren County.
They declined to join us.
They declined to join us. Okay. When did they decline? A few minutes ago.
I did an order of appearance. I sent them a Zoom link, and then I got an email saying that they had no one scheduled for court today, so I'm not sure what else to do.
Who do we have in Warren County?
Trey Williams.
Well, he's in federal custody, may be the problem. So I just moved to continue it generally until he's out of federal custody.
Okay,
That's my case, and I thought we had agreed to dismiss that. In speaking with Mr. Hunley before the last court date,
I'll just continue it and y'all can talk about it.
If it's fine, I won't talk to the feds before I dismiss it.
Well, he's not here. We can't get him on. I'm continuing it till it's read up.
Okay.
Allen County. Allen County.
I did the same. I did order of appearance and some.
Okay, probation parole's gone. Have him get Allen County.
He's here with me, Your Honor.
Have him call Allen County and see if we can get Dylan Hardin online.
Okay,
just for an arraignment. Tell me it won't take a second, just for arraignment. Okay, Barron County. Barron County. Okay. Now, officer, do you have any preference on how we call them?
No, Your Honor.
Okay, Isaac Atkinson.
Yeah.
Commonwealth versus Isaac Atkinson, 21 CR 00125. Are you Isaac Atkinson?
Yes, sir.
Okay, we're here today for pretrial conference. Ms. Hill, is this your client?
It is, Your Honor.
Do y'all have an agreement?
Your Honor, we do not. This is one of the cases that I mentioned previously that we're waiting on an investigator for. Our new investigator starts on May the 16th, which is only 3 days prior to our next pretrial conference. I'm asking the court if you will continue until the June pretrial date, which should give us enough time to contact the witnesses that we need to speak to.
I don't mind, Your Honor, as long as he would be held without bond. He was out on an ankle monitor. In court, I can put Ricky Richardson on as a witness. He was everywhere on the ankle monitor from Barron County to Hardin County.
What, June what? June 30th. Okay, that's fine.
Hey, Your Honor.
Jeffrey Ballard.
Your Honor, can I say something to you?
I don't know what you're going to say. You have a right to remain silent. And your attorney, maybe you ought to consult your attorney before you say anything.
I just like to apologize. I went out to eat in the middle of the night, sir, with a female. Like, I just like apologize. I do like let you know I do have a job though. I do have a job, and I was doing stuff right. I can pass a drug test and everything. I had permission to go to Nashville to see my sick grandma, and I went out to eat in the middle of the night, sir. But I was doing everything else right. And I do have a job, sir. I'm not trying to get fired.
Okay, well, thank you very much. And your attorney will be talking to Commonwealth attorney about your issues, okay? Jeffrey Ballard. Commonwealth versus Jeffrey Ballard. 22 CR 0010, 22 CR 0011, and 22 CR 0012. Are you Jeffrey Ballard?
Yes, sir.
1980?
Yes.
Last 4 digits, social security number 8424.
Yes.
Okay, we're here on a pretrial conference. What do we have, Ms. Hill?
Your Honor, we have a resolution to this case.
A diversion or a felony plea?
It is a diversion agreement, Your Honor.
Okay, a motion's been tendered, Mr. Ballard. It says you wish to enter a plea today. Is that correct? Is that correct?
Yes, sir.
Currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes.
Are you the same person named in indictments 22 CR 10, 11, and 12?
Yes.
Is your judgment impaired today in any way?
No, sir.
Have you discussed these charges with your attorney?
Yes.
Are you satisfied with the advice of your attorney?
Yes.
Reviewed the evidence that the Commonwealth has against you?
Sorry.
Have you reviewed the evidence the Commonwealth has against you?
Yes, sir.
Okay. Do you understand that you do not have to plead guilty today? You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, the right to be represented by counsel at a jury trial, the right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, the right to call witnesses in your favor, and the right to appeal this matter to a higher court if you lose. You have a right to require the Commonwealth to prove beyond a reasonable doubt that you are guilty of the charges against you. You understand by the entering a guilty plea today, you give up those rights. I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept the recommendation. In the event that I do not accept the recommendation and decide to impose a harsher penalty, you have a right to withdraw your guilty plea and proceed to trial. Have you previously been diverted in the last 5 years?
No, Your Honor.
Have you have any felonies in the past 10 years?
No.
You're currently on probation. You understand that you must fully complete, if you fully complete the diversion program, the charges will be dismissed, pretrial diverted. If you do not complete the diversion program, you'll be brought back before the court and decide whether or not to revoke your pretrial diversion and schedule a sentencing hearing. At that time, you would be a convicted felon, and that could be used against you in the future if you had further felony convictions. You understand that?
Yes.
Mr. Stockton, will you go over the agreement and see if this gentleman says this is what he agreed to?
Yes, Your Honor. In 22 CR 10, Mr. Ballard will plead guilty of possession of controlled substance first degree, receive a sentence of 2 years. In 22 CR 11, he'll plead guilty of possession of controlled substance first degree, receive a sentence of 2 years. In 22 CR 12, he'll receive a sentence of 1 year on possession of a controlled substance first degree. All 3 cases will run consecutively for a total of 5 years. Pretrial diverted for 5 years. It's to be supervised. He will have to enter and complete the Monroe County Specialty Court Program, and he'll be released upon orientation. He'll pay court costs at discretion of the court, obtain and maintain gainful employment. All evidence in these cases will be destroyed.
What is the court cost in this case? $355 court cost. Will you need some time to pay that when you get out, sir?
Yes, Your Honor.
Okay, I'll let you pay it at $30 a month, starting 30 days after you get out. Are you pleading guilty of because you committed the acts charged in the indictment?
Yes.
Okay, well, knowing your constitutional rights, is it still your desire to allow me to go ahead and sign this pretrial diversion order and subject to possibly a felony conviction if you do not? Okay, I will accept the agreement. I'll sign it, and then they'll set you up for the drug court orientation and things like that, and we'll let you out on that date, okay? Okay, thank you very much. Jacob Boles. Jacob Boles. Commonwealth versus Jacob Boles, 22 CR 002. You're here today, Mr. Boles, for the purpose of arraignment. Mr. Boles, what is your year of birth?
2002.
For the last 4 digits of your social security number.
1163.
The grand jury of Monroe County has returned an indictment charging you with operating a motor vehicle with expired operator's license, possession of an open alcohol container, driving too fast for the traffic conditions, and trafficking in marijuana. Would you take this back to the public defendant, public advocate? Counselor, do you acknowledge the identity of your client? She's straight back there in a room somewhere. Would you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea if not guilty?
Yes, Your Honor.
Reserving all pretrial motions. Mr. Stockton?
Yes, Your Honor.
What kind of quantity of marijuana was involved in this?
Let me look real quick. We have a lab report back on that. It was quite a bit, Your Honor. It was 875 grams. So that would be 28 grams an ounce. You're looking at probably in excess, almost 2 pounds of marijuana.
Okay. Okay, what kind of bond is this individual? Pre-trial on? Pre-trial, are you on?
Yeah, yes, Your Honor. I'm here, Your Honor. He is showing that he has a $15,000 clerk-approved surety with pretrial monitoring, 24-hour curfew, and standard conditions, Your Honor.
Okay, have you talked to your client? Thank you. Have you talked to your client as to why that's pretty low bond, 15,000 surety? What's the deal?
Your Honor, I have not spoken to Mr. Boles about his bond or bond situation.
Boles, I'll speak to him. Mr. Boles, do you not have anybody you just sign a $15,000 surety bond? They don't have to. It's not much. Anybody, virtually anybody that owns anything can do one of those.
I ain't got anyone that can do that. I ain't got no one that can do that.
It's pretty good.
Your Honor, would you consider, given the nature of Mr. Boles' charges, doing a unsecured bond on this with some sort of ankle monitoring?
Well, it would cost you more to do the ankle monitoring than it would do it's more expensive than just somebody coming in and signing a bond. All right, do you have a job anywhere, Mr. Boles?
I had a job at the Alice Nursing Home in Ripple.
Yeah, you lost that job because it's arrest here?
Yes, sir.
I'm gonna let him do it. So you're a Tennessee resident, huh? Is that right? You're from Tennessee?
Yes, sir.
Yeah, well, that's probably one of the, you have any family in Barron County or Monroe County?
Yes, I do.
Who do you have here?
My uncle and my aunt.
I'm gonna reduce it to a $5,000 clerk approved surety. That way somebody can come in and convince the clerk they have a net worth of $5,000, they can sign your bond. Now, the problem is that you live down in Tennessee. I still want you under a curfew. I want you at home, and I want you staying at home except for court, work, church, the doctor, those sort of things. In other words, an old Monroe County phrase that you might not have down in Tennessee is I don't want you out gomming around. Do you understand what I'm saying?
Yes, sir.
Okay. You come back here on the, you be back here on the 13th for negotiations, and on the 19th, and be in touch with your lawyer, okay? I want you to sign a waiver of extradition. We'll send it over there to the jail, which means that you'll agree to come back to Kentucky without us extraditing. You understand that?
Yes, sir.
If you make bond, you'll come back to Kentucky without us having to extradite. You understand what I'm saying, sir?
Yes, sir.
Your Honor, if I could ask Mr. Boles to get one of my cards from the jail before he leaves.
That'd be good if he leaves. Would somebody in the clerk's office send a waiver of extradition filled out over there for him to sign? Thank you very much. Jonathan Brown. Jonathan Brown. Commonwealth versus Jonathan Brown. 21 CR 00111. Are you Jonathan Brown? Born in 1976. Passport is your social security number 0306. Here today for the purpose of sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by Probation and Parole? You find it to be substantially correct?
Yes.
There was one mistake on that, Your Honor. On page 12, it lists his birth date as 1975. It was 1976. It's correct everywhere else. That was the only.
Also, there was a mistake in the plea offer. It's 2 3-year runs can run concurrently for a total of 6 years. It should be consecutively.
That's correct.
Is that correct, Mr. Bassett?
Yes, Your Honor.
You what?
Yes, Your Honor.
Okay. Upon a plea of guilty to theft by unlawful taking or disposition under 10,000, defendant shall receive a sentence of 3 years. Upon a plea of guilty to trafficking a controlled substance, first degree, first offense, defendant shall receive 3 years. The 2 3-year sentences shall run consecutively for a total of 6 years. Serve 120 days in jail. With about probate, he shall forfeit $822 to Commonwealth they need to quieten down there to jail some. Is that where the noise is, or is it picking up somewhere else? Thank you. The 2 3 years shall run consecutively and serve 130 days. Defendant shall forfeit 822. The defendant shall be referred to the social condition, follow the guidelines that they set out, no contact with the victims. He's to credit, he shall pay $5,000 fine and court costs in the amount of $195. The defendant shall remain on supervision until all restitution and applicable fines and court costs are paid in full. Now, what kind of payments a month are in the agreement now?
There was no monthly payment contemplated, Your Honor.
Well, can you pay it all, sir?
Yes.
Okay. Well, you pay all of that and then that'll take care of it. Okay. Well, thank you very much. And I guess the probation parole officer will be able to see you get the final information. Okay. Thank you very much.
Your Honor.
Yeah, I don't know either. How many days did he have in, you know?
The pre-sentence investigation report shows 71 days, Your Honor.
We just got a few more days, right? What was that? 120. So he's over halfway there. So.
Yes, Your Honor.
Okay, I'm going to go to Allen County. I think they've joined us now. Thank you, Allen County, for being on there with us.
I'm sorry about that, Your Honor. We didn't.
No problem. We live in difficult times, and some of the things the legislature passed can make it more difficult. So. Yeah. Okay, this is Commonwealth Kentucky versus Dylan Hardin. 22 CR 0023. You're here for the purpose of arraignment. Mr. Hardin, what's your year of birth?
8/14/1993.
The last 4 digits of your social security number.
0633.
Okay. The grand jury, you have a right to remain silent. Your attorney is on there from Office of Public Advocacy. The grand jury has indicted you, charging you with driving on suspended operator's license, fleeing or evading the police in the first degree, wanton endangerment in the second degree, possession of controlled substance, and possession of drug paraphernalia. Mr. Bailiff, you take that back to Office of Public Advocacy back there. Counselor, you acknowledge the identity of Mr. Hardin, receipt of the indictments on a way formal reading and arraignment, enter a plea of not guilty, preserving all pretrial motions.
Yes, Your Honor.
Okay. You have a negotiation day on May the 13th, and your court appearance will be on May the 19th, and both of those are conditions of your bond. Is Mr. Hardin being held in Allen County on other charges?
Yes, sir.
Okay. Well, your attorney will work out some kind of arrangements for us to help you make the court dates over here, either by Zoom or we'll send an order over, depending on and the cooperation of the local officers here with Allen County. Okay. Thank you very much.
Judge,
Allen County. Yes.
Judge, could I give him our collect number, as it's not freely available over there as it is in Barron County?
Yes.
Okay. It's 502-564-4211.
Okay. And I'm signing a reciprocal discovery order here, Mr. Hardin, where they're going to give your attorney the evidence they have so she can start preparing your defense. Okay.
Yes, sir.
Okay. Allen County, thank you for your cooperation.
Thank you, Your Honor.
Y'all have a great day. Okay. I guess we're back to Barron County then.
Judge, it's Phil Kimball. How are you this morning?
I'm great. How are you doing?
Well, I'm fine. I'm here with them this morning. I had court over here, so I came to the jail after I got done with court. So I'm here with Matthew Muse I think we've got an agreed order that we tendered on him is all we need to do on that. Would you see if that is with his
Commonwealth
file?
of Kentucky versus Terry Muse.
Yes, sir.
Okay, 21 CR 0015. Mr. Stockton, what do you have on that?
Yeah, we have an agreed order, and basically, I think it's in the court file. Basically, Mr. Muse would have no contact with the victim. He would relocate to Lexington. He would get mental health treatment at VA, and he wouldn't come back to Monroe County or this jurisdiction without permission of his probation officer. I think those are the key elements of the agreed order that's in the file. He entered a plea agreement to an assault case. Miss Anderson worked out with the victim in district court, and that this was part of that.
That's correct, Your Honor.
What's the underlying charge?
It was a domestic violence case with the victim, and this is one of these cases, if I had the power and I was a dictator, I'd put them both in jail forever because they won't stay away from each other. And that's the basis of this agreement.
How do you really feel about it?
Other than that, I won't tell you how I feel about it.
Yeah. I'm a little hesitant, quite frankly, Mr. Muse, if you have violated a domestic violence order. But the Commonwealth's making this recommendation, and evidently they have more information, I'm sure, than I do about it. But I will tell you that you need to stay away from this person out of Monroe County. And I hope you get some anger counseling or something like that, because with this floating out there, you know, if you were to get charged with another violent situation, some of this could be introduced at the trial as far as other bad acts. Your attorney will tell you, I believe. Okay, I'll sign the order.
Thank you, Your Honor.
Yeah. Mr. Kimball, do you need an order getting you out of there, or you think you can?
I think they're going to cooperate with me, but I'll text Jesse if I have a problem.
You're overdressed. I can tell you that, to be in the jail. Those people there. Okay.
Yeah,
Thanks, Jesse.
You're welcome. Mr. Muse still needs to call Chase Collins when he gets out. He's probation parole officer.
Absolutely. Thank you.
Jonathan Brown. We just did Jonathan Brown. Amy Cropper. I forgot to check Jonathan off. Amy Cropper.
Hey.
Commonwealth versus Amy Cropper, 21 CR 0084. Are you Amy Cropper?
Yes, sir.
You're here today for a pretrial conference. Mr. Garrett, who is using Johnny Bell's computer.
We're in the same room. Judge, we've got a plea on this.
Okay, is it a felony or a diversion?
It is a felony, Judge.
Okay. Ms. Cropper, you're born in 1981.
Yes.
Last four digits, social security number 3772.
No, did not make it in there.
3717.
Okay. A motion's been tendered, says you wish to enter a guilty plea today.
It was in there at one time.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given? Is this plea freely and voluntarily given?
Yes.
Are you the same person indicted under 21 CR 0084?
Yes.
Have you had opportunity to talk about this matter with your attorney, and are you satisfied with his advice?
Yes.
Okay. You believe you're fully informed about your case?
Yes.
You have certain rights under the Kentucky and United States Constitution. I want to know that you fully informed those. Are fully informed about those. I want to go over those, and at the end, you can say whether you or not you are acknowledge that you're aware of that. You have a right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, right to be represented by counsel at your jury trial, a right to cross-examine and confront all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor and have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose. You have a right to require the Commonwealth to prove on a reasonable doubt that you're guilty of charges against you. Do you understand that by entering a guilty plea today, you give up those rights? Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence allowed by law. I do not have to accept a recommendation. Prior to any sentencing recommendation, I will await the pre-sentence investigation report from probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. And listen very carefully as Mr. Stockton says what he believes the agreement to be. Mr. Stockton.
Your Honor, Ms. Cropper will plead guilty in 21 CR 84 to burglary, 3rd degree, receive a sentence of 5 years. She would plead guilty to 3 different information indictments. One was 22 F58, $500 fine on no insurance. Also, in that case, she would plead guilty to possession of a controlled substance, 1st degree, 3 years to serve. Also, in 22 F58, by new information indictment, she would plead guilty to failure to comply with sex offender registration, receive a sentence of 5 years. All those sentences would run concurrently for a total of 5 years, but those 5 year sentences would be consecutive to 18 CR 36, which I believe she's either been revoked on or is going to stipulate the revocation. Then the all evidence in this case would be destroyed. And the Commonwealth would oppose probation or shop probation.
Is that what you agreed to, ma'am? Is that your understanding of the agreement you reached?
Yes.
Okay. Are you pleading guilty because you committed acts charged in the indictment?
Yeah, yes,
Okay. You're doing so of your own free will. Is that correct?
yes,
Knowing your constitutional rights have explained, is it still your desire to give up the rights to enter plea of guilty to the charges, allow the court to fix punishment within the range permitted by law? Is that correct?
yes,
Okay, you understand that after entering guilty plea, any future convictions could enhance the range of penalty under those convictions. You understand that?
yes.
Okay, now you have a copy of the agreement there with you.
I have it.
You hold it up to the camera there, make sure she identifies her signature.
Yes.
Okay, I will accept the agreement, order a pre-sentence investigation report, and schedule a sentencing on May the 19th, okay? Thank you very much. Erica Decker. Erica Decker. Commonwealth versus Erica Decker, 20 CR 0067. Are you Erica Decker?
Yes, sir.
Okay, you born in 1986.
Yes, sir.
Last 4 digits, social security number 1879. Is that correct?
Yes, sir.
Represented by Office of Public Advocacy here on a pretrial conference. What do you have, Counselor?
Your Honor, we have a resolution to the case.
Is it a felony plea or a diversion?
A diversion, Your Honor.
A diversion, okay. A motion has been tendered that says, Ms. Decker, that you wish to enter a guilty plea today. Is that correct?
Yes, sir.
Okay, are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Okay, you're the same person named in indictment 20 CR 0067.
Yes, sir.
Is your judgment impaired in any way today?
No. No, sir.
Are you satisfied with the advice of your attorney?
Yes, yes, sir.
Have you had plenty of time to review the evidence of the case? You feel like you thoroughly understand that?
Yes, yes, sir.
Okay, you have certain rights in the Kentucky United States Constitution. Before I can accept your plea, I need to know that you fully understand those rights. I'm going to go over the rights with it, and at the end of it, I'm going to ask you if you understand them, okay? You have the right not to testify against yourself. No one can make you say anything. Right to speedy trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. You understand that by entering a guilty plea today, you give up those rights. Okay, now I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept the recommendation. In the event that I do not accept the recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Now, have you previously been diverted in the last 5 years?
No, sir.
Do you have any felonies in the past 10 years?
No, sir.
Are you currently on probation?
No, sir.
You understand that if you fully complete the diversion program, the charges will be dismissed.
Yes,
You
sir.
understand if you do not completely if you do not successfully complete the diversion program and you get brought back into court, and I can schedule a pre-sentence investigation court report and in a hearing, you'll be a convicted felon that could be used against you in a future felonies. You understand that? You understand that?
Yes, sir.
Well, if you don't, tell me.
I do.
Okay. Now, are you pleading guilty because you are guilty of committing the acts charged in the indictments as amended?
Yes, sir.
Okay. Knowing your constitutional rights that I explained to you, is it still your desire to give up those rights? Enter this plea and allow the court to fix the punishment.
Yes, sir.
Okay, will you hold the document up there and let this lady see her signature? Okay, right there, look in the camera there. You see that? Is that your signature there? Okay. Well, I'll accept the agreement and sign the diversion order. There wasn't any drug court or anything in this, was there?
No, Your Honor, she was to be released, be placed on active supervision, obtain gainful employment, and pay court costs.
Okay, what are the court costs in this case? $265 in court costs, and I'll let you pay that at $30 a month, the first payment 30 days after you get out. Now, you'll need to make arrangements to go to probation and parole officer. When do y'all want her at the probation and parole office?
We'll be in Glasgow Monday.
Glasgow office Monday morning at 9 o'clock.
9 o'clock. I'm going to take a chance on you here, young lady. I'm going to let you out today. Is that okay?
Yeah, that's okay.
Okay, that's the right answer. Okay, now you've been at probation and parole office clean. Okay, on at 9 a.m. It would be a bad start to this thing if you went in there with a dirty test or anything. Okay. Okay. Well, the papers will come over a little later. Okay.
All right. Thank you.
Thank you. Chase Dotson. Okay, I've been informed, Mr. Stockton, that Chase Dotson has been sent to rehab.
Didn't know it. He needs to be sent to penitentiary.
Well, there he is.
I'd like to. I need to schedule a hearing.
Mr. Garrett. I thought that was Mr. Dotson, and when he said get sent to the penitentiary, it just flashed
we'll
on
make
there.
arrangements for both if we need to. But no, I'm serious. He's had 5
Okay,
positive
what we need to
tests.
do is we need to make arrangements to get him here. Where, do y'all know where the rehab is?
He needs to be in custody. Is there not an arrest warrant out for him from the probation officer? Because I'm dealing with a foreign probation officer here.
Wait a second.
Yeah.
Do you have to agree for them to go to rehab?
I don't know how he got to rehab. King Garrett got him there. Yes.
No, I didn't get him there.
Well, take credit for it, you know. Geez.
Well, I mean, I'm just being transparent with the court.
Well, I know, but it's good for business. Say you got him in rehab, you know. So.
I'm not sure. It says that the bench warrant was recalled on February 7th.
Chase Collins, are you on there?
He's here. Yes, Your Honor.
Did we recall a bench warrant on this fellow?
We did. If I remember correctly, he absconded. But during that time, we absconded and requested a warrant. He was actually in rehab then.
Okay, but since then he's got a new assault case and a new positive meth case. Since I've got that he got an assault 4th on April the 1st and admitted meth use on April the 1st.
What about that, Chase?
And Chase also told me he's got a theft by deception and a dare count. So he's been busy since he's been in rehab.
Okay, we'll issue an arrest warrant for him. We'll schedule him on the next rule day. Actually, when he gets into custody, we'll schedule, if we get him there, we have him on the 13th and the 19th. If he's not in custody, we'll just have him here on the 19th. Thank you very much. James Forrest. James Forrest.
Judge, Joanne took the same motion.
Joanne Tooley is also the co-defendant. Is that correct? That's what,
Yes.
okay. And it's a motion for video deposition. Is that correct?
Yes, Your Honor. After we subpoenaed all the lab personnel in this case, the serologist is due to have a child toward the end of May and will be on maternity leave. So I wanted to know if we could take her testimony by video deposition rather than continue the trial. I know Miss Tooley was adamant that she wanted a trial last time, was real vocal about it, so I want to accommodate her.
Well, I will do that, but these two individuals here have a right to be present with their attorney so they can consult with him during the deposition. So we'll have to do a transport order to bring them over here. When do you have a date for the
Well, we could do it. I guess we could do it the 13th if the court wanted
I
to.
don't, I don't have to be here for the deposition.
Okay. Well, there may be objections to the testimony. So that's the reason.
Well, I mean, I can be on video is what I'm telling
Okay.
you.
Okay.
Jesse,
So-
on the 13th, I'm already in a murder case in Allen County that week.
Well, I'll tell you what, Mr. Garrett and I will get some dates and run them by you, Your Honor, if that's okay.
Okay, that's right. What's the date of this trial now?
It's in June 13th, I think.
Starts on a Monday now instead of a Tuesday, doesn't it?
Yeah, I have to get the deposition taken sometime by the middle of May if or she's not going to be available.
You know, I've got a lot of time, and
Okay.
so let's get some dates from the witness, and then maybe you and Mr. Garrett and I, with the permission of your clients, Mr. Garrett, can meet and pick a date. Okay.
Sure.
Okay. Thank you very much. Damian Hamilton, sentencing. Commonwealth versus Damian Hamilton. That is 21 CR 00120. You are Damian Hamilton, is that correct?
Sir.
Born in 1995. The last four digits of your social security number are 1940. Is that correct?
Yeah.
You're here to go for sentencing. Your attorney is online here. Have you had an opportunity to look at the pre-sentence investigation report done by Probation and Parole?
Yes, sir.
Is it substantially correct?
Your Honor, there are some issues with the charges that are on the PSI. It says on the PSI that the PFO charge was amended to a PFO second from a first. Mr. Hamilton had pled guilty to the trafficking in a controlled substance Class B felony, as well as the possession of a handgun, and the PFO had been dismissed.
Well, that's what it says on here, doesn't it? Or you have a copy of the PFO. It says dismissed possession of drug paraphernalia and dismissed persistent felony offender first degree 1 count.
Your Honor, the PSI that I reviewed with Mr. Hamilton yesterday had it on there that the PFO had been amended to a second. So I was just clarifying with the court that had been dismissed.
There may have been confusion because we changed the plea at the last minute on get your all's request. So
She says she says,
You're reading the plea. If you flip it over, you'll see where the charges are wrong. To the PSI. That's the plea. Keep going. To the plea, that's your PSI. That's where she's saying it's showing that it's not dismissed.
so in the plea agreement, it says that, but the pre-sentence investigation report does not say that. That's what you're saying.
Yes, Your Honor. The pre-sentence investigation report does not indicate that the PFO had been dismissed.
Was that the agreement, Mr. Stockton?
yes, he was going to plead guilty to a B felony with the PFO being dismissed.
Upon a plea of guilty to trafficking and controlled substance first degree Class B felony fentanyl, defendant will receive a sentence of 12 years. Upon a plea of guilty possession of handgun, the defendant shall receive a sentence of 10 years. The 12-year sentence and 10-year sentence will run concurrently for a total of 12 years. 12-year sentence will run consecutively to Monroe County 18 CR 0005. Credit for time served. agrees to forfeiture $822 dispersed in accordance with the forfeiture. Agrees to forfeit the weapons involved and black muzzle attachment. That the controlled substances will be destroyed. Agrees to release, including the other personal property, including the Apple phone, to the defendant or representative of the defendant. Since the term is as long as it is, I'm going to waive court cost. So I'll combine all the court costs on all the charges and waive it. Okay.
Thank you,
sir. Okay. Okay. Thank you very much. Devin Howard. Commonwealth versus Devin Howard. 18 CR 00173. You are Devin Howard. Okay, we're here for a pretrial conference.
Paperwork on that.
You're represented by the Department of Public Advocacy. What do y'all have in this case?
Your Honor, we have an agreement on this case for a misdemeanor. I will note we received paperwork while in court, and the jail accidentally, I think, forgot to have Devin sign the Commonwealth's offer to plead guilty. If the court, I can always run by after court at this time, the guilty plea, just not the offer form.
Wait just a second. Mr. Howard's raising his hand. What do you have to say?
Yes, sir. I was going to say they actually just brought the paperwork in here to me, and I actually signed it just like probably 20 minutes ago.
Judge, if we want to recall that, and I'll run down to the clerk's office and get the.
He said he'd signed it.
Okay. Do you want me to go run down to the clerk's office since they're sending it now?
They can send it now, or you can hold it up to the camera. It's just a misdemeanor.
Correct.
But just have him send it over here and we'll call him back out of an abundance of caution. Okay.
God bless you on Godspeed. Thank you, sir.
We'll see in a few minutes. Yeah. Shannon Keith. Shannon Keith. Commonwealth versus Shannon Keith. 20 CR 0038. Your year of birth 1975. Last four digits of your social security number is 0956. You're here today for the purpose of arraignment. You have an attorney?
No.
Did this go through district court? Did public advocacy represent you in district court?
No, I have not yet, Your Honor.
Okay. Well, I'm gonna let public advocacy stand in for you here for the purpose of arraignment. Then you can fill the papers out and I'll appoint him. Do you have funds to provide a private lawyer? Or are you going to get a private lawyer?
No. No.
Okay, well, I'll just go ahead and appoint them then. This is 20 CR 0038. Mr. Keith, I previously said you were born in 1975, last four digits, social security is 0956. Is that right? You're here today for the purpose of arraignment. You have a right to remain silent. What we're going to do is just read the charges. If you have any questions, you can ask your attorney. You're charged with flagrant non-support, about $21,570 as of June 11th, 2020. Mr. Bailiff, will you take that back there? Okay, Counselor, do you acknowledge the identity of your client? Receive the indictment, waive formal reading, arraignment, air plea of not guilty.
Yes, sir.
Reserve all pretrial motions. Okay. Okay. Where do you live, Mr. Keith?
Right now, I'm staying up in Tompkinsville at the hotel.
Okay.
Okay.
What do you have, Mr. Stockton, about it?
He's been in NCIC. We had to locate him, Your Honor. And with that amount of child support, I just asked that we have at least one pretrial before he's, or a bond hearing.
Okay. May the 13th for your negotiation date, and May the 19th. Your attorney will be coming to talk to you, okay? Zachary Law. Commonwealth versus Zachary Law. 21 CR 0022. Are you Zachary Law? Were you born in 1997? Last four digits, social security number 2596. Represented by Office of Public Advocacy. We're here on a pretrial conference. Counselor, what do you have on this?
Your Honor, there has been a motion filed that I believe we'll need to take up after the docket.
Is it an ex parte motion you filed?
Yes, Your Honor.
We wouldn't want to have Mr. Stockton believe that we're trying to leave him out unless it was an ex parte motion. Okay. So is there anything, but let's talk about where we are on the case. I'll look at the ex parte motion, but where are we on the case?
Your Honor, I believe that we will need at least another pretrial conference on this case. I don't believe that we are ready to resolve with the issues that I will be raising in that ex parte motion.
Okay, let's set him for a negotiation on the 13th, and the next court date is on the 19th. I'm going to take a brief pause here. It'll be about 4 minutes. I'll be right back.
I got what I got about 9 pounds done. Oh, yeah.
I don't think so. I said something. Somebody else that we just can't do the stage. Okay, I believe we're on Steve Martin. Is that correct? Commonwealth versus Steve Martin. Are you Steve Martin?
Yes, sir.
Okay, this is, you born in 1977. Last four digits, social security number 7663, sir. Okay, this is 21 CR 0080, 21 CR 00105, and 21 CR 0079. What do you have? Who's representing?
That would be me, Your Honor. This is another case like Mr. Atkinson's where we were waiting on an investigator to be able to go out and do some work for us on this case. The investigator starts on May 16th, which is a little bit close to our next pretrial date. So I was asking for a continuance until the June date.
That's fine, Your Honor.
Okay. What is the June date? June the 30th. What is the negotiation day in June? Do what?
We don't have one, probably be the second Friday in June, if that's all right with Ms. Hill.
Okay, what is that date? I don't have a calendar in front of me. What is that date?
June the 10th.
June the 10th for negotiation and June 30th for the next court date. Okay, well, thank you very much. Nathaniel Meador. Nathaniel Meador. Nathaniel Meador.
Do we have Nathaniel Meador here? They're bringing him, Your Honor.
Okay, thank you. We'll go on to James Mercer. What's your name, sir?
James Mercer.
Okay, this is 18 CR 00124, Commonwealth, Kentucky versus James Mercer. Mr. Bell is your attorney. You see him there. Rather happy looking fellow there on camera. This is a motion for shock probation. What do you have to say?
Your Honor, it's basically a motion to revoke shock probation. He was out about a month and he got a DUI. Mr. Bell wants him to go to long-term treatment through probation and parole. If we can do that with the court's approval, I will agree to it. But this is about his last chance.
Yeah, I don't know about these DUIs.
He's not been convicted. We can pass it till he gets a resolution in Barron County.
Let's pass it to see what the resolution is on the thing.
And Judge, if I may, one terrible thing happened to Mr. Mercer. His grandfather that raised him passed away during that time. So there was some terrible circumstances surrounding the whole issue. I would just like to
I have my sympathy for his loss.
That in the resolution date on that, on the DUI is in July. So I don't know how long it's gonna
Are you
be.
defending him on that, Mr. Bell?
I'm not, Your Honor.
Do you have an attorney on the DUI?
Yes, it's Christina McGinnis, I think.
If you recall, Your Honor, I stayed on this case when we were doing this. I just told the court I would, so I don't have his other case. I'm doing this one pro bono on this part.
Yeah.
Which I don't mind.
I am willing to go to rehab and follow everything I need to do. All recommendations.
Well, Mr. Stockton, look into the DUI a little bit. I want to ask Mr. Bell to do it. Who can you contact his lawyer on that? See what the plan on that is.
Yeah, I can contact the county attorney's office and see what.
Contact the county attorney's office, and I'll consider it with an agreed order. But I mean, there are two things that really bother me on these. Put your hand down there just for a second. I'll ask you again. Two things is a driving under the influence and weapons charges. Those are the two things that really bother me when people are out on probation and parole. Okay, so they'll be in contact with you, Mr. Mercer. Okay.
Thank you, Judge.
Okay, thank you.
We
have Nathaniel Meador.
Who's going to be in contact with me, Judge?
Your attorney on the DUI case. The Commonwealth attorney is going to get a hold of the county attorney in Barron County.
Okay.
And they're going to talk about your DUI case to see what the circumstances are. And then since Mr. Bell is just doing it out of the charity of his heart. With Mr. Stockton will be able to talk to him about it, and we'll see. But let me tell you something. You're out on you're on probation and you get a DUI. Now that jail over there is full of people that have done less than that. So you just be patient. Don't act impatient. Okay. Okay. Thank you very much.
I just want to understand.
Joshua Perry.
I got Nathaniel Matter for you, sir.
Okay. Nathaniel Meador, please. Are you Nathaniel Meador?
Yes, sir.
Okay, we're here today in 22 CR 00017, Commonwealth of Kentucky against Nathaniel Meador. Were you born in 1997?
Sir.
Last four digits of your social security number 2309. Is that correct?
Sir.
Okay, we're here today for a purpose of arraignment to read the charges against you. You have the right to remain silent. If you have any questions, your attorney is on the line there. The grand jury of Monroe County has returned an indictment charging you with theft by unlawful taking or disposition. You see that? Mr. Bailiff? Counsel, the indictment is on the way back. I've got the reciprocal discovery order here that I'm going to sign, and they're bringing your attorney information back, laying on her desk over here that will help her prepare the case. What is this? What is the bond in this case? Let's see here.
Yes, Your Honor. It's a $15,000 surety.
Yeah. You don't have anybody that can make a surety bond for you?
She said that she had tried to come and buy me out, but she could, I don't know if they had paperwork right or not, but Mama was going to. She said it didn't want to lower it down. I don't know.
Well, it's just a $15,000 surety. They don't have to put any money up or anything.
That's what I was thinking.
Yeah. What do you think, Mr. Stockton?
Would be his mother signing the bond?
Who's signing the bond for you?
Mama.
Your mother? Okay, I'll do a $5,000 surety bond with the other conditions. You need to be at a curfew at, you should live with her, or who you live with?
I'll be staying with her.
Okay, you stay there with her. You stay at home except for work, church, doctor, or court appearance. If you have to go anywhere else, you need to call pretrial and tell them why, okay? Okay, thank you very much. Joshua Perry. Joshua Perry. Pre-trial, will you turn your camera off there and you can monitor us without that on? That way you won't be on the record. Thank you so much. Commonwealth versus Joshua Perry, 22 CR 0033. Are you Joshua Perry?
Yes, sir.
Okay. We're here today for the purpose of arraignment in 22 CR 0033. Were you born in 1991, sir?
Yes, sir.
Last four digits, social security number 5880. You
Yes,
have
sir.
the right to remain silent. Your attorney is there online with you. So if you have any questions, you'll be able to ask her. The grand jury of Monroe County has returned an indictment charging you with public intoxication, fleeing or evading the police in the first degree, disorderly conduct in the first degree, and assault in the third degree. Do you understand those charges? Here you go, counsel. Okay. You take that back to public. I'm signing a reciprocal discovery order here where they give you evidence. Okay, the next court appearance will be on the 19th of May, and on the 13th have a negotiation day, okay?
Judge, if we could address Mr. Perry's bond, my understanding in district court is he was on an ankle monitor and did very well on that and maintained employment and still has the employment he had prior to being indicted available to him if he were to be released.
Well, they've indicted him, charged him with assault of a police officer, is that correct?
They have, Your Honor.
Well, I mean, anytime we deal with that issue, I want some explanation as to why he shouldn't be held. Mr. Stockton, have you looked into this?
I know Deputy Richards, former Deputy Richardson told me he did real well while he was on ankle monitor. Let me see what the officer wants in this case.
Yeah.
I've got it written down here.
Were you working somewhere, Mr. Perry?
Yes, sir, I was.
Where are you working at?
Other than framing.
Okay, can you go back to work if I put you on an ankle monitor?
Yes, sir.
Okay,
I don't believe the police officer would object based on his recommendation.
okay. He would not object?
He would not object based on his
Well, I'm gonna go
recommendation.
ahead and, I'm gonna let you have a $5,000 surety bond. Is that what he was in district court?
He was an unsecured bond, Your Honor, but do you have someone that can sign, Mr. Perry?
I could, but my wife is epileptic and she cannot drive, so I don't know how she would get up here. And I live in Thompsonville, Kentucky.
Where are you gonna be residing at when you get out?
Same address on the paper, 322 Willow Branch.
That in Tompkinsville?
Yes, sir.
Okay.
Well, I believe you'll have somebody in your family that can sign a, Mr. Richardson's here. You think there'll be somebody in his family probably will sign a $5,000 bond?
He said they're all from Tennessee.
They're all from Tennessee, but you live in Kentucky, right?
Yes, sir.
Okay, well, I'm gonna, since you behaved well on the ankle bracelet before, I'm going to let you, do an ROR and you can sign the bond yourself and get the ankle bracelet signed up and go to work, church, the doctor, or court. And if you go anyplace else, you'll need to call the monitoring agency. They'll give you a number. Like if you got somewhere else you got to go. Okay. 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 We'll see you on the 13th and the 19th. Both of them are conditions your bond. The 13th will be for negotiation and the 19th will be your next rule day, your next court date. Travis Pike is next. Travis Pike. Commonwealth versus Travis Pike. Are you Travis Pike?
Yes, sir.
Okay, we're here in 21 CR 00129 for the purpose of arraignment. Mr. Pike, were you born in 1992? And then the last 4 digits of social security number 3590. Now you have a right to remain silent. Your attorney is on the line right there. If you'll see, I'm going to read the charges against you and give her a copy of the indictment so we can arraign you. The grand jury of Monroe County has charged you with kidnapping and unlawful transaction with a minor in a 3rd degree, also with theft, unlawful taking or disposition. Okay, Counselor, you acknowledge the identity of your client, receive the indictments on your desk. The pretrial compliance is on your desk. I'm signing a reciprocal discovery order here. Mr. The grand jury, I guess, Mr. Travis, it says Travis Paul Wayne Pike, got a whole bunch of names. What's the situation on Mr. Pike's bond?
We had him in NCIC quite a while before we could locate him.
Okay. Well, your attorney will have to negotiate with the state and see what kind of bond, and she can schedule, you're entitled to a bond hearing, one bond. I don't want to.
Hey, Mr. Pike, you can take one of our cards and we can discuss this with you, okay?
Okay. I don't want to burn your bond hearing up today without you talking to your attorney. I could say today, but you only allowed one bond hearing by right, so we'll reserve that. So that will be on May the 13th for negotiation and May 19th, next court appearance. Both of them are conditions of your bond. Danye Pippin. Danye Pipkin. Commonwealth versus Danye Pipkin. 22 CR 00124. You're Danye Pipkin.
Yes.
You were born in 1972 and the last four digits, social security number 7728.
Yes.
Okay, we're here today for a pretrial conference. Is that correct?
That's correct.
What have you got here?
Judge, we have got an offer from Mr. Stockton. I would like to try to continue to negotiate that, but I'll leave it up to the court's discretion if they want to give us one more pretrial or set Mr. Pipkin for a trial date.
I don't mind, Your Honor, either way. I did discuss the case with Mr. Bell. I'm just kind of waiting to hear back from him, Mr. Pipkin.
Okay, well, May the 13th will be your negotiation day. And if you reach some agreement before then, we could hear you in one of the other counties, I guess, if you wanted to. So May 13th and May 19th, okay? Thank
Yes,
you
sir.
very much. Yeah. Danny Pippin. Danny Pippin. Commonwealth versus Danny Pippin. 21 CR 0045 and 21 CR 0046. Mr. Pippin, were you born in 1980?
Sir.
Four digits, social security number 8968.
Yes, sir.
We're here on a pretrial. What do you have, Mr. Stockton?
We have a felony plea, Your Honor.
Okay. Mr. Pippin, a motion has been filed that says you wish to enter a guilty plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictment number 21 CR 0045 and in indictment number 21 CR 0046?
Yes, sir.
Have you discussed this matter with your attorney today, and are you satisfied with his advice?
Yes, sir.
Have you had plenty of opportunity to review the evidence of the case and you believe you're fully informed?
Yes, sir.
You do not have to enter a guilty plea in this case. You have certain rights under the Kentucky and United States Constitution. Before I can accept your plea, I'll need to know that you understand those. So I'm going to go over your rights and at the end ask you if you understand them. You have a right not to testify against yourself. No one can make you say anything. Your right to speedy trial by jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. You understand that by entering a guilty plea here today, you give up those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence allowed by law. I do not have to accept the recommendation. Prior to accepting the recommendation, I will await a pre-sentence investigation report done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. Listen very carefully, sir, as the Commonwealth announces their recommendation. Mr. Stockton.
Your Honor, the Commonwealth will move to dismiss 21 CR 46 with possession of a controlled substance first degree. Co-defendants already pled in that case. In 21 CR 45, Mr. Pippin would plead to receiving stolen property, receive a sentence of 2 years. He would also plead to tampering with physical evidence, receive a sentence of 2 years. They would run concurrently for a total of 2 years to serve. The Commonwealth would oppose probation and shock probation. He would have $300 to pay in restitution in accordance with the restitution order. And any and all controlled substances in 21 CR 46, he would agree to destroy.
Is that what you agreed to, sir?
Yes, sir.
Okay. Are you entering a guilty plea here because you did commit the acts charged as amended?
Yes, sir.
You, knowing your constitutional rights, Abbott says it's still your desire to enter this plea and allow the court to fix your punishment within the range permitted by law. Is that true?
Yes, sir.
Okay, now you understand that after entering a plea of guilty of this felony conviction, any future convictions could be enhanced under persistent felony offender law as far as the range of penalty.
Yes, sir.
Okay, Mr. Bell, do you have a copy of the agreement there with you?
Yes, sir, Your Honor.
Will you hold it up to the camera and let this gentleman, is that your signature there, sir?
Yes, sir.
Okay, well, I'll accept the plea Order pre-sentence investigation report done by probation parole and have you back here for sentencing on May the 19th. Okay, thank you very much. Orlando Shirley. Commonwealth versus Orlando Shirley, 22 CR 007. You are Orlando Shirley.
Yes, sir.
Born in 1973. And the last four digits, social security number 0944. Is that correct?
Yes, sir.
You're here for a pretrial conference on 22 CR 0007. What does the Commonwealth have to say in this case? Mr. Stockton.
In this case, Mr. Shirley would plead guilty to possession of a controlled substance, receive a sentence of 2 years. It would,
Is it a felony plea, is it?
it's a felony plea.
Okay.
It will,
Let me go ahead and go down through this stuff and then
Okay.
move to your part here in a minute. A motion's been tendered, sir, that says you wish to enter a plea today. Is that correct? Are you currently on the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Really?
Yeah. Are you the same person named in indictment number 22 CR 007?
Yes, sir.
Discuss this matter with your attorney and are you satisfied with her advice?
Yes, sir.
Have you reviewed the evidence Commonwealth has against you? You believe you're fully informed about the case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I accept a plea of guilty, I need to know that you fully understand these rights. You have the right not to testify against yourself. No one can make you say anything. The right to be trial by jury, the right to be represented by counsel, jury to trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter, higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges. You understand that, but entering a guilty plea today, you give up all those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided below. I don't have to accept the recommendations. Prior to accepting recommendations, I will await a pre-sentence investigation report to be done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Listen very carefully, sir, as the Commonwealth announces their recommendation. Mr. Stockton.
Your Honor, in this case, there's 2 counts of possession of a controlled substance, first degree. Mr. Shirley would plead guilty to both counts, receive a sentence of 2 years on each count for a total of 2 years run concurrently. That 2-year sentence would run consecutively to Monroe indictment number 21 CR 96 for a total of 5 years. He would enter and complete the Monroe County Specialty Court Program, receive credit for time served. He would be released upon his orientation. He would pay court costs at the discretion of the court. All evidence in this case would be destroyed.
Is that what you agreed to, sir?
Yes, sir.
You pleaded guilty because you are guilty and committed acts and the indictment is amended. Is that correct?
Yes, sir.
Knowing your constitutional rights have explained, is it still your desire to give up these rights, enter guilty plea and allow the court to fix the punishment in the range permitted by law?
Yes, sir.
Okay. Is that, you have the signed document there? Is that your signature, sir?
Yes, sir.
Accept the agreement, order a pre-sentence investigation report to be done by probation parole. We'll have your sentencing on May the 19th.
Judge, is there any way Mr. Shirley can be released? He was last court date on a revocation action. There was an agreement for him to do drug court. I don't know if he's been accepted, but it's been a month and he has some significant mobility issues due to a disability.
You'll need to talk to the Commonwealth attorney about it, and then y'all can present an agreed order if he's in agreement with that. I don't want Mr. Shirley deny him the opportunity to be heard on that today. So y'all go ahead and talk about it and get back with me, okay?
Mm-hmm.
Tanisha Shirley. Tanisha Shirley.
Gonna treat him any different.
Tanisha Shirley.
And
18 CR 00192. Are you Tanisha Shirley?
Yes, sir.
Okay, we're here on 18 CR 001. Are you born in 1996?
Yes, sir.
And last four digits, social security number is 0775. We're here today on a motion for shock probation.
Yes, Your Honor, and Brad Gordon here with the Georgetown Public Defender's Office I filed that motion. If I may, Your Honor, I filed this motion on shock probation. For shock probation, I would start off that the charge that Miss Shirley was convicted on is probation eligible. There's no bars in statute prohibiting probation on this. Let me start with the first thing, that she has a significant amount of jail credit on this. At the time of, by my count, she's got at least 580 days of credit on this. She had 467 days as of December 8th, 2021. And then at this point, an additional 120 days from that date to this juncture on this case. Her PSI did indicate she was a low moderate risk, so she would be a good candidate for probation if the court was willing to grant shock probation on it. And obviously, Miss Shirley would adhere to any terms of probation that the court did impose on her, including, particularly a substance abuse assessment and following all recommendations of treatment, as Miss Shirley has done well in the past on treatment after completing PSAP. In this case, I know she did remained out of trouble for quite some time. I know she did pick up some new charges eventually, but after having some structure and some treatment, she did do quite well for some time, Your Honor.
Mr. Stockton.
Your Honor, if the court recalls the facts of this case, Miss Shirley was in a house with numerous individuals. In fact, there was about 7 or 8 people indicted in this case. She was hiding under her person about 70 grams of meth. Miss Shirley didn't offer much of defense at trial. I don't know if she even offered any. She successfully shielded, I think, many of the co-defendants from any culpability in this case. And I think due to her success, she should serve the sentence that the jury imposed, because she's been protecting people all during this process.
What about these new charges that she got?
I think she had a possession plus these other charges. I'm not aware of any charges since she's been sentenced or anything.
I'm sorry.
Yeah, and if she's been charged with anything since she's been incarcerated, she's been in custody for a long time.
And Your Honor, I can clarify on those charges that she has picked up since this case has started. She still does have a pending Barron County case that is holding her in jail. However, if the court could.
Was she out on bond when she allegedly committed these charges?
She was, Your Honor. There were 2 charges.
It doesn't go very well with me.
Fair enough. I can tell you on one of those charges, she already has served out, Your Honor. It was she took a year to serve on a possession charge, and she has already served that time out.
While she's serving this, right?
Yes, correct. While she's serving this.
Yeah. Well, I'm going to deny the motion for shock probation and let the jury's verdict stand. Okay. Thank you very much.
Mercer, Your Honor.
Yeah. Dwayne Spears. Dwayne Spears. Are you Dwayne Spears, sir? You're here on 21 CR 0016106. Mr. Spears, were you born in 1984?
Put a pin in on him so he gets it.
Mr. Spears, are you Dwayne Spears? Are you saying yes?
Yes, sir.
Okay, you don't have to speak up. It's voice activated. Mr. Spears, were you born in 1984?
Yes, sir.
Last 4 digits of social security number 9377.
Yes, sir.
Okay, you're here today on a probation revocation. What's the Commonwealth had to say?
Your Honor, Mr. Spears was on probation for supervision for possession of controlled substance first degree. It was a 3-year sentence. On 3/31 of 22, he was positive for meth, and he advised Mr. Collins he took a drug cleanser, trying to eradicate that from his system. I talked with his counsel and Mr. Collins, and we're willing to put him in drug court if the court's willing to. If not, we'd proceed with the revocation.
Mr. Spears, are you willing to try drug court turn your life around?
Yes, sir.
Okay. I have no objection. You send me an agreed order and I'll do the
Now,
referrals.
he'll have to stay in custody until he's oriented. He needs to.
It'll take a while, Mr. Spears, but it won't be as long as you would if you go to the penitentiary. I can guarantee you that. Okay?
Thank you.
Okay, Matthew Stout. Commonwealth versus Matthew Stout, 22 CR 004. Are you Matthew Stout?
Sir.
You're born in 1987.
Yes, sir.
Last four digits of your social security number.
696.
Okay, we're here today for a pretrial conference. You have an agreement in this case here?
No, we do not yet have an agreement in this case, but I've spoken with Mr. Stockton and we are working towards one. I would ask if the court could continue this until the next pretrial and negotiation dates.
You have any objection to that? Mr.
No,
Stockton?
Your Honor, I believe we're pretty close on the case.
May the 13th is the next negotiation day and May the 19th is the next court day. Both of them are conditions of bond. Okay? Thank you very much. Terry Strode. Commonwealth versus Terry Strode. You need to go back there and bar the public defenders. Commonwealth versus Terry Strode, 22 CR 0032. Mr. Strode, your attorney is present. He's going back, get online here. He'll be here in just a second. You're here for the purpose of indictment, return of indictment. You have the right to remain silent. The grand jury of Monroe County has returned an indictment. Are you on there yet? Mr. Poindexter, are you there yet?
Yes, Your Honor.
Okay. Need to turn the camera on. Okay, there you go. The grand jury of Monroe County has returned an indictment charging Mr. Strode with three counts of trafficking and controlled substance in the first degree, in possession of drug paraphernalia, possession of marijuana, possession of a handgun by a convicted felon. Do you understand those charges, Mr. Strode, Mr. Bailiff? You're, take those back to Mr. Poindexter. Mr. Poindexter, you acknowledge the identity of Mr. Strode.
I do, Your Honor.
The receipt of the indictment, it's on the way back there to you. You waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions, and I'm signing a reciprocal discovery order. If Mr. Poindexter, let's just take it back to Mr. Poindexter. That's it. Okay. And your discovery is on the way back there too, Mr. Poindexter.
Yes, sir.
We'll next schedule this case for May the 13th and the 19th.
Yes, sir.
Now, how many cases, is this going to be a priority case, Mr. Stockton, or what? You have other indictments? When are you going to elect?
Well, I think this is it. And as soon as we get the lab report back, we'll be ready for trial in this case. It shouldn't be very much longer. It's already been submitted.
Okay. Okay, well, there's no reason to have a conference if it's not back 13th, is what I'm asking. Is that right?
Yeah, it may be. If it is, we'll get to Mr. Poindexter. I'll let him know.
Okay, we'll schedule it for the 13th for negotiations and the 19th for the next day. Okay. Thank you very much.
Thank you, Your Honor.
Yeah. Donnie Tooley.
Hey.
Donnie Tooley.
Morning.
Morning. Commonwealth versus Donnie Tooley, 21 CR 0043, 21 CR 004, 21 CR 005. We're here today for the purpose of sentencing. Mr. Tooley, have you had an opportunity to look at the pre-sentence investigation report done by Probation and Parole?
Yes, sir.
Is it essentially correct?
Yes, sir.
Okay. Counselor, is there any reason why this gentleman should not be sentenced today then?
No, Your Honor.
Capay, upon a plea of guilty, the Commonwealth made the following recommendations. On plea of guilty to indictment number 21 CR 004 for the charge of trafficking in first degree, he shall receive a sentence of 10 years. On indictment number 21 CR 004 for tampering with physical evidence, he received 5 years. The 10 years and 5 years shall run consecutively for 15 years. Under indictment number 21 CR 004, he agrees to forfeit $1,395 to Commonwealth of Kentucky to be dispersed in accordance with a forfeiture order. Under indictment number 21 CR 005 for trafficking and controlled substance first degree, the defendant shall receive a term of 10 years. Under the indictment number 21 CR 005, he shall receive forfeit $237 to Commonwealth to be dispersed according to the forfeiture order. The 15-year term and the 10-year term in the two cases 04 and 05 shall run concurrently for a total of 15 years with the balance probated as of the entry of balance probated with the credit for time served. Under indictment number 21 CR 0043, the Commonwealth agrees to dismiss this case in its entirety without prejudice on the condition that the defendant forfeits $657 to Commonwealth of Kentucky and be dispersed according to the forfeiture order. He shall receive credit for time served. And what is the court cost? Okay, I'm going to merge all three cases. And
7 or 8, 6 or 7 months or something.
so it'd be $276.50. Will you need some time to pay that, sir?
Yes, sir.
I'll let you pay it $30 a month. The first payment due in 30 days after you get out of jail. Okay.
Okay.
Okay. Thank you very much. Jesse Turner. Jesse Turner.
Yes, sir.
Commonwealth versus Jesse Turner, 20 CR 0003. You're here for sentencing. Your attorney, Mr. Bates, is on the line. Have you had an opportunity to review the pre-sentence investigation report done by Probation and Parole, sir?
Yes, sir. I done that.
Okay. Is it substantially correct?
Judge, there were a couple of corrections.
Okay.
The first and most important correction is that we had by agreement added in that this case would run concurrently with Barron County 21 CR 76 and 19 CR 464, and that's not reflected in the final sentencing document.
With my staff lawyer says it is in the judgment. It's going to be reflected in the judgment.
Okay. And that's fine, Judge. We just wanted to make sure that that was in there. The other issue is, and I know that the court doesn't do direct corrections of time calculation. We think that the 496 is very short of the amount of time that he should have in. I believe he was originally arrested on this case back in 2019 out of district court. And I think he was only released for approximately 6 to 8 days. And so he should have quite a bit more time than the 496.
I'll note that you, for the record here, that you're reserving the right to challenge the calculations as far as the time administratively. And I believe there is relief with the court if your administrative relief doesn't go through.
That's correct, Judge. And I've informed Mr. Turner that he needs to first appeal that through the Department of Corrections once he gets his timesheet. And if that is not, if they're not able to get that taken care of, then we can come back to the court.
Yes, sometimes Mr. Turner has to do with the right numbers on the cases and things not being applied. So they'll look at that and go through it. If it satisfies you, you'll find if it doesn't, you can have your attorney bring it back in front of me and make your case for your time served. Okay. Okay. Well, thank you very much.
Thank you, Judge.
I'm going to waive the court costs considering the amount of time he's been in there. So there won't be any court costs. Okay.
All right. Thank you, Judge. We appreciate that.
Okay. No problem.
Yeah.
That's it for you. I guess we got Kelton Withrow. Is that the only other one we have? Oh, we got one other after that?
And I believe we still have Devin Howard at the jail as well.
Okay, well, let's go back. As you come up here, young man, just have a seat right there and we'll get to you. I'm sorry I called you up too early here. Let's go back. Yeah, there it is. Commonwealth versus Devin Howard, 18 CR 00173, a pretrial conference. Y'all have an agreement on this case?
Yes, Your Honor.
Mr. Stockton? We got Devin Howard. I forgot to call Devin Howard up. Is this a
It's a
felony?
misdemeanor plea.
Misdemeanor
Misdemeanor.
plea. Okay.
Yeah.
Okay, well, I'll go through some of the sort of things. Mr. Howard, you've previously been identified in this case. Go back to the case number.
Sweet. Don't get no better than that.
18 CR 00173, Mr. Howard. I understand that you have reached an agreement and signed a plea with the Commonwealth. This is a misdemeanor, I understand, but you still have certain rights that I want to go over with you, okay? You have the right not to testify against yourself. No one can make you say anything. Right to speed trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called, testify against you, the right to be evidence, the right to call witnesses in your favor, have process issued to compel their attendance, the right to appeal this matter to higher court if you lose, the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charge. You understand by entering this guilty plea, you give up those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept the recommendation. I can reject the recommendation. Since this is a misdemeanor, there will not be a pre-sentence investigation for it. We'll make that decision here today. If I do not accept the Commonwealth's recommendation and decide that I will not accept a misdemeanor plea, you have the right to withdraw your plea. Mr. Stockton, will you say what the agreement is?
Yes, Your Honor. In this case, he will plead guilty to possession of drug paraphernalia, class A misdemeanor, get 90 days in jail. That will run concurrently with 18 CR 32, where he's a state inmate, which is a felony. So basically, the cases will merge. There'll be no additional time.
Okay. Is that what you agreed to?
Yes, Your Honor.
Well, okay, I'll go ahead and sign the misdemeanor judgment today when it's submitted. Correct? Yeah, y'all do the misdemeanor judgment, submit it to me, and I'll sign it. Okay, I think that's everybody at the Barron County.
God bless y'all. May peace and blessings be upon y'all.
He is serving at the same time with his state.
No, there's a 12-month sentence, served 90 days. What are they doing?
12 months probated, served 90 days. Is that correct?
I guess that's what I'm.
Wait a second, Mr. Stockton.
90 days, but it doesn't matter because he's a state inmate. It's going to merge. He's not going to have any additional time. It's a misdemeanor plea under state law. The felony and the misdemeanor merge. It's run concurrently with the felony.
I understand, but let's say that he gets out, but within the 90 days, for example. I don't know what Megan said. We don't know when he's in or out. So is it just a 90-day?
It's 90 days, but it's going to merge with the felony.
We understand it's going to merge. No problem. We just didn't know whether to put a 12-month with.
No, it's just a straight 90 days.
Okay, well, that's what we're trying to ask you. Okay, that's good. Okay, thank you very much.
God bless y'all.
Yeah, thank you, sir.
Your Honor, one last thing I wanted to ask you, whatnot.
Where is your attorney? Your attorney's not here. Wait a second.
No, it wasn't anything about anything important. I was just wanting to know, was y'all gonna send my paperwork and stuff over to the jail so we can process it and stuff and
Yeah, we'll roll it out of here as soon as we can. Okay.
All right, buddy, because I know on the 23rd of last month, they didn't get none of my paperwork when I was in front of you. And I was like, oh my God, man, what's going on?
Yeah. Well, I hope you get it over there today. Hope you. Hey, if I don't see you again, I don't have a sentencing on him. It's all over. If I don't see you again, I hope you can turn your life around, man. Okay.
Right.
See you later.
I appreciate it. God
Okay.
bless you.
See you now. Thank you so much.
Thank you, Your Honor.
Okay, thank you very much. Now we're back here live and in person. Monroe County Justice Center in downtown Tompkinsville, Kentucky. Okay. Now, would you identify yourself, sir? That is. That is 18 CR 00172. Mr. Withrow, were you born in 1985? Well, they've done added 10 years. You've gained 10 years of life right here. Your attorney done a good job for you today. 1995. Okay. Last four digits of social security number 6409. I understand y'all have a plea today. Is it a felony plea or a pretrial diversion? Misdemeanor plea. Okay. Okay. You're going to go over it here, Mr. You have, I'm going to go over your rights with you anyway, because you have certain rights under the Kentucky United States Constitution. I need to know you understand. You have the right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called testify against you, right to produce evidence, right to call witnesses to favor process issue, compel their attendance, right to appeal this matter to higher court if you lose, and right to acquire Commonwealth prove beyond a reasonable doubt that you're guilty of the charges against you. You know, okay, now the Commonwealth will have a certain recommendation in here. I don't have to accept the recommendation. If I reject the recommendation, however, I'll allow you to withdraw your plea. You can go to a jury trial. Now, are you entering a plea because you are guilty of the amended charges? Is that right? I can't hear you. You got to say it's voice activate. You know what I mean? Okay. Okay, is that your signature on the document there? Okay, if y'all move to your left, Mr. Judd is going to go over and see if this is what you agreed to. Okay.
Your Honor, Commonwealth agrees to dismiss the danger to the welfare of a minor, 2 counts, Class A misdemeanor.
Yeah.
Dismiss trafficking and controlled substance, first degree to Class C felony, trafficking marijuana, Class C felony. Upon a plea of guilty, the Commonwealth recommends upon the plea of possession of drug paraphernalia, the defendant shall receive a sentence of 12 months with the balance of probate for 2 years supervised. The defendant shall receive credit for time served. The defendant shall pay the fine and court costs discretion of court. The defendant shall remain on active supervision until all restitution of applicable fines and court costs are paid to the court. Further support. The defendant shall obtain gainful employment at a minimum of 30 hours per week until gainful employment is obtained. And the co-defendants and this defendant all agree to have any and all evidence in the above style case disposed of according to Lawson.
Okay, this probationary period is for how long in a misdemeanor?
It's 2 years.
2 years? Yeah, okay.
I don't need to interrupt. The version of the paperwork that we have has an amendment signed by Mr. Stockton that says that it's to be unsupervised.
Okay. Don't have that. I will.
Okay, you're gonna move back over here. You still need to check in with probation and parole and get signed up and everything. So you got this time on the shelf. Correct? So I don't know what happened here. Evidently, there's some other people had accepted some responsibility and things like that too. So you got a chance all this stuff could be expunged. Just like once you get past this, it can be expunged. You won't have any record from this, and you can go ahead and have a productive life. And I hope that happens for you. Okay. Okay. The probation parole officer is right over there. I'll go ahead and y'all need to submit us a misdemeanor judgment. Thank you very much. Okay, who else do we have here? Is that it?
I see says
We sent Seth Collins. Be careful tonight. Don't too much celebrating now. Yeah, what's okay, is there anything else that we got that's on docket? Okay, then we have some. I will turn the microphone off here.
Your Honor. I'm going to excuse myself and log on to Barron District Court if that's okay.
That's just the way you are. You always. Thank you very much.
Thank you, Judge. Bye-bye.
Yeah, bye. Let's see here if I get that mark off.